Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of a number of proposed rules to further the Commission's actions on the Dodd-Frank Reform and Consumer Protection Act. Today we'll be considering, I think it's 6, but let me list them. 6 rules, I think. Certification and approval of rules and new products for designated contract markets, derivative clearing organizations, swap execution facilities, and swap data repositories. These are rules that we would have on how they move forward on their rules. Secondly, removing, as the Dodd-Frank Act asked us to do, any reliance on credit ratings in various Commission regulations. Thirdly, amending various regulations we have to provide greater protections for customer funds held by futures commission merchants and derivative clearing organizations. Fourthly, a process for review and the designation of swaps for mandatory clearing. Fifthly, enhancing the Commission's ability to protect against manipulation. And then sixth, an advance notice of proposed rulemaking. This isn't actually a proposed rule, but it's to ask the public, I think it's 18 questions. Advance notice of proposed rulemaking on disruptive trading practices. Before we hear from the staff, once again, I want to thank my fellow commissioners for all their hard work on the Dodd-Frank Act and all of our existing authorities. I believe that Commissioner Dunn, I just want to make sure, is tied in somehow through modern technology. But is Commissioner Dunn with us?
I am here. I am here.
Terrific. So we have. Oh, and he's on the video there in our Chicago office, if I understand it right. I'd also like to welcome members of the public, market participants, and members of the media to today's meeting, as well as welcome those listening and watching via webcast. This is our third public meeting to consider Dodd-Frank rulemaking, and including today's actions, I anticipate that we'll have published 2 final rules, one of them called an interim final rule. I think that we will have proposed 11 rules, if the rule count is correct, and published 3 advance notices of proposed rulemakings. And while a great deal of effort has gone into this is still likely only to be about a quarter of the work that we have. And that's only a quarter in the first phase, called proposals, because, of course, really the very important work of finalizing these rules next spring will be before us. We currently plan to have at least 3 public meetings in November and 2 public meetings in December. The dates and topics will be published, of course, in the Federal Register, and we're looking to our next meeting on the Dodd-Frank Act rulemaking on November 10th. The arithmetic, of course, will show that this will be a very busy next 7 weeks. And no doubt, as we're humans, some of these rules may slip, and there'll be news stories, I guess, on whatever that may be. But our goal is really to complete the proposal stage by mid-December. And as you'll see, even on this disruptive trading practices, we'll probably have that proposal after mid-December because we thought it was appropriate to go out to the public and get more information. I want to thank the staff for all of the work that they've put in drafting the rulemakings and consideration today. Thank them for their thoughtful recommendations how the Commission shall go forward. And we look forward to receiving the public comment, which is really just enormously critical for us. These, again, are just proposals that we're considering. So each of these rules will have a series of questions in them and seek public comment. We're also putting fact sheets and Q&As on our website, which I hope will help the public understand what we're doing. Before we turn to the staff, I'd like to turn to my fellow commissioners for opening statements. I think Commissioner Dunn, if we can do this through the video conference.
Thank you, Mr. Chairman. Is this working?
Yes.
Can you hear me?
We can hear you very well.
Very fine. Well, today we will consider the next set of proposed rules that come before the Commission pursuant to the Dodd-Frank Act. As with other proposed rules, today's set of rules offers a glimpse into the resource-intense re-engineering the CFTC will be doing throughout to provide regulatory framework to implement many new responsibilities under Dodd-Frank. As I have previously stated, I'm very concerned about the CFTC budget situation and possible attempts to thwart implementation of the Dodd-Franks by cutting off funding for this agency. There was just a piece in Reuters this morning indicating that that might be one strategy. Without the requisite level of funding, I see possibilities of several unfortunate outcomes as a result of that. Let me enumerate these. First, without the necessary human capital to review CEFs, DCMs, and DCO applications, I can envision long waiting periods for potential registrants before their applications are approved to conduct business in the markets we regulate. This inability to quickly and efficiently process applications, no fault of the CFTC, would undoubtedly prevent the immediate creation of a competitive market environment, at least in the OTC space, and may lead to a greater systemic risk as positions become concentrated in a small groups of CEFs, DCMs, and DCOs that are not first to navigate the registration process. Similarly, the lack of adequate resources may undoubtedly affect the agency's ability to approve new products for trading. If the CFTC does not have people to review new product applications to ensure they are not violative of the Act and are not readily susceptible to manipulation, the new products cannot be listed for trading. Again, I fear a long queue will develop for new products waiting approval, and that the inability to get new products approved will prevent innovation and competition in the markets. Without adequate funding, the CFTC may need to delegate a substantial portion of its duties under Dodd-Frank to the industry's established SROs. If we cannot be the frontline regulator, it is incumbent upon the Commission to find someone who will be. Delegation of this oversight duties to the existing SROs will obviously be very costly to them, but necessary. And lastly, a principle-based regulatory regime only works if the regulator has the staff necessary to ensure that its regulees are adhering to the principle. Without sufficient staff to conduct proper oversight, the CFTC may need to write a more prescriptive set of rules and rely more heavily on burdensome reporting requirements. Again, this undoubtedly would be very costly to the industry and market users. It's my hope that the CFTC will receive the necessary funding and will allow us to continue to provide the quality oversight it has always provided. This oversight, following a principle-based approach, in my opinion, fosters an environment of compliance, competition, and innovation. Mr. Chairman, I want to thank you, and I want to thank the staff for, again, hosting these series of meetings. I think this has been one of the most open processes that any regulator has ever had, and I appreciate all the hard work that has gone into it. Thank you.
Thank you, Commissioner Dunn, for your remarks, and Commissioner Summers.
Thank you, Mr. Chairman. I want to say that I, first of all, agree with many of the comments made by Commissioner Dunn this morning regarding our resource restraints, and hope that that gets worked out as Congress returns. I'd want to say thank you to the rulemaking teams this morning for all the hard work that have been put into these proposals that are before us today. And I guess I had thought that with proposing our 11th rule today out of 30 rulemaking teams that we were a third finished. Not a quarter finished, but...
Commissioner Summers' math is very good.
Okay,
very
good. I was thinking, there's something I don't know about this.
Well, I do have to admit that Sarah Josephson has broken her business conduct into numerous rules, so I don't want to, so...
There's more than we even knew. Anyway, thank you very much. I look forward to discussing the important rules before us this morning.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I agree with the fiscal concerns that were raised by Commissioner Dunn and then last week by Commissioner Summers and constantly by our chairman and by our former appropriations staffer, too. This is important because we're dealing with anti-disruptive practices and with manipulation. The law has been really weak in these regards over the years, which is why many of us sought to get it changed in this rule. The proposal will help promulgate these things, and we'll be able to better enforce the rules, make more efficient, effective markets in the future. I did want to take just a moment to comment on precious metals, and in particular, silver. We've been having an investigation that's been going on for 25 months now, and I've been urging, not that there's any individual that hasn't agreed, but I've been urging that we say something publicly at some point. I think that the public has been for 2 years asking about whether or not there's widespread manipulation in the markets, and it just seems to me that after a couple of years we should say something. We can say yes, we can say no, but say something. The legal definition, as I said, of manipulation is really hard to prove. It's a high bar. It's a much different test. It is a much different test than what the average person, if we walked out on the street, might think of as manipulation. Because you not only need to have a specific intent, but you also need to prove as a result of that intent and market control that that activity caused an artificial price. And causing an artificial price is something that can be debated by economists. So it's a really high bar. But what we're doing today will help in that regard. Attempted manipulation is a little easier to prove than manipulation. It requires the intent to manipulate and some overt act in furtherance of that intent. And then there are lesser violations. There's several of them. And after we do disruptive trading practices, there will be even more. So we're going to be adding additional tools to our sort of toolbox of things that can help in these markets. I do believe that there have been repeated attempts to influence price in the silver markets. There have been fraudulent efforts to persuade and what I consider deviously control that price. And this is based upon what I've been told by members of the public and reviewed in publicly available documents. I believe there are violations to the Commodity Exchange Act that have taken place in the silver markets, and that any such violation should be forcefully prosecuted by the government. Now, in saying this, I'm prohibited from divulging anything about our investigation, about giving individual trader names, or about positions, and I'm specifically not doing that. And I can't prejudge anything that my colleagues and I may or may not do on this or any other matter. So I appreciate that we're going forward on this. I believe that disruptive trading and the anti-manipulation rule, along with position limits, will help not only the precious metals markets when they're fully implemented, but will help all markets, make them more efficient, effective, and devoid of fraud, abuse, and manipulation. Thank you.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you, Mr. Chairman. I'd like to thank the teams who have spent many long hours developing these rules that we will consider here today. The staff has actively sought input from the commissioners and worked cooperatively to improve each of these rulemakings. I'd like to thank Bella Rosenberg and her team, Adrian Jovis and Eileen O'Donovan, and their respective teams. I'd also like to thank Phyllis Dietz and John DeBoard for their efforts. However, I'm quite concerned about the proposed rules with the investment of customer funds. I think they're overly prescriptive, especially given that the Commission released an advance notice of public rulemaking on this very issue in May of 2009. My main concern with this proposal is that the Commission is proposing to significantly revise the scope and character of permitted investments of customer funds in the face of numerous public comments to the contrary. In fact, the concentration limits in today's proposed rule seem to suggest that the 2,000-plus pages of Dodd-Frank have done nothing to improve the safety and the liquidity of the money market funds. I strongly urge the public to comment on the reasonableness of the asset-backed concentration limits, especially the 10% limitation on money market funds. I also question whether it is wise to allow 50% of the allocation to be invested in one government-sponsored enterprise. I intend to oppose the rulemaking as it fails to consider public comments and fails to provide sufficient justification for the proposed allocations. Moving to anti-manipulation, I'd like to thank Bob Pease and Mark Higgins for their efforts to present us with rules regarding an incredibly controversial area of our law. In the vernacular of the futures industry, there is one term that stands out above all others: manipulation. M is the scarlet letter of the futures market. When the Enforcement Division, traders, and the defense bar speak of the big M, they are thinking of a specific kind of conduct, the intentional creation of an artificial price, as Commissioner Chilton pointed out. It requires having specific intent to affect prices in a manner that is not legitimately brought about by the forces of supply and demand. To fully comprehend the scope of this rulemaking and the advance notice of proposed rulemakings on disruptive trade practices, one must understand the range of prohibited misconduct under the CEA. To do this, it helps to think of the possible violations of the CEA on a continuum ranging from trade practice violations such as wash trades to the full manipulation. New sections provided by the Dodd-Frank Act provide additional points along the continuum in the form of disruptive trading practices and fraud-based manipulative schemes. The placement of these points on the continuum will be determined by these rulemakings. The foundation of the Commission's rulemaking authority is preserved in one end of the continuum through the new Section 6C3. These rulemakings mirror the statutory prohibition to clarify the Commission's interpretation of price manipulation as an intentional interference with the legitimate forces of supply and demand. It is important to note this will not change the Commission's enforcement under the existing 9A2. Fraud-based manipulation schemes described in new Section 6C1 differ from the Big M manipulation in that the prohibited conduct may be intentional or reckless, and that there is no requirement for such conduct to result in an artificial price. Taking one step back along the continuum, disruptive trading practices are also defined in some instances as reckless conduct. Accordingly, a trade strategy that is executed under unpredictable, atypical market conditions could misfire and fall under the enumerated disruptive trading practices. If the Commission determines that the strategy was engaged in recklessly, it could find that the strategy was manipulative, even if the trader had no intent of to impact market prices or disrupt the market itself. This would be an aggressive outcome, but is entirely possible on this continuum. It is therefore incumbent upon this Commission to be clear about which type of activity is prohibited and how we intend to use our new authorities. Last week, NFL Commissioner Roger Goodell notified players that striking an opponent in the head and neck will result in far more significant discipline, including suspension. When I read this, I realized that Commissioner Goodell's job is very similar to that of the Commission. He places a high priority on protecting the players from needless injury. The CFTC also places equal value on protecting market participants from manipulation, market disruptions, fraudulent behavior, and other abuses. The new statutory provisions charge us with defining controls to ensure that trading is neither disruptive nor manipulative. These provisions also impose high penalties for conduct which may only be reckless, a rather low standard under the law, to ensure that market participants are incentivized to follow the rules. To the NFL's credit, it has been very specific about what it will and will not tolerate. However, in my opinion, our rulemaking will not provide market participants with the same comfort or sufficient direction. This is especially true with regard to disruptive trade practices. One would think after requesting language in the legislation, the Commission could provide some more details as to how it will interpret the language on spoofing or trading in the close. As a result, it is appropriate for the Commission to receive more feedback from the public to better refine these definitions and understand how they might impact markets or the players affected. And I appreciate, Mr. Chairman, you going with an advance notice of proposed rulemakings to further flesh these out. We must not lose sight of the technology investments such rulemakings might require. In order to effectively oversee trading schemes and practices, the Commission will need to reconstruct the order book and to understand how various bidding strategies have impacted market prices. Regardless if we apply intent or reckless standard, all cases must be supported by the facts and empirical data. As we work through the particular rulemakings, it is critical to remember that our responsibility is broader than simply responding to the last crisis. Going forward, prevention and deterrence must be the twin goals that are furthered by anti-manipulation and disruptive trading rules. Stating up front that the Commission may always go back to the instant replay to review the call on the field does not provide market participants with a fair notice as to when their strategies will run afoul of the rules. It is my sincere request that the public provide input on the complicated rulemakings to ensure that everyone is in agreement of the boundaries of fair play. Thank you.
Thank you, Commissioner Malia. I want to thank all my commissioners, fellow commissioners, for their comments, and I find myself associating with each of you in different ways. I hope it's a third, by the way. I definitely associate with Commissioner Dunn on the need for resources. I'm going to continue to be sort of a happy advocate for resources, and I truly do hope that when Congress comes back from the election, that we get the necessary resources to move forward. I do believe even our estimate of 400 new staff to incorporate Dodd-Frank may well end up being a low estimate, given that the markets that we're to oversee probably will have 300 to 400 new registrants, and the markets, at least in notional size, are probably 7 to 9 times the size of the markets that we currently oversee. And I can find myself associating with Commissioners O'Malley and Chilton, though maybe a little bit different perspectives, on the need to have clear rules of the road on anti-manipulation and disruptive trading practices. I do think that we need to enhance our authorities in that regard, and Dodd-Frank gave us that. Let me turn over to the staff presentations. The first set of proposed rules that we're considering today relate to something in our commission which we call Part 40. Part 40 is just part of our rules, and these are about how we as a commission approve or consider the various rules and new products of registrants. That's what Part 40 is. But Bella Rosenberg from our Division of Market Oversight, I guess with support from her boss, Rick Schiltz at times, is going to discuss these proposals. With that, I think I might even just go through, I see. I'm supposed to go through and introduce everybody. So here I'm going to introduce everybody. The second set of proposals being considered today will address the removal of the reliance on credit ratings and proposals, alternatives to this reliance. I don't see, where's Adrian? So Adrian Jovez from our division of the Office of General Counsel is going to present that. The third set of proposed rules being considered relate to the investment of customer funds under Regulations 1.25 and 30.7. It also, in that set of rules, will regard the use of credit rating agencies as well. And I believe that I see Phyllis sitting there. Are you going to present this then? Or John's going to do it with you. So John DeBoard from our Division of Clearing and Intermediate Oversight, maybe with an assist from Phyllis, is going to present that. The fourth set of proposals describes the process for reviewing swaps for mandatory clearing. Eileen Donovan, where's Eileen? There in the second row. We'll be doing that again from our Division of Clearing and Intermediate Oversight. The fifth set will be addressing this discussion about the manipulation standards, where I think Mark Higgins and Bob Peace will be coming to the table from our Division of Enforcement. And then finally, there will be the proposals regarding disruptive practices, and Bob Peace will be doing that. In terms of the staff will present the proposal in each case, and in each of these we'll have the floor will be open for questions, and we'll take a vote. So on number one, Bella, I think if you want to give a presentation, and then we'll do a motion.
Good morning, Mr. Chairman and Commissioners. Today, staff is recommending that the Commission approve a notice of proposed rulemaking to implement new rule certification procedures for existing registered entities, such as designated contract markets and derivatives clearing organizations, and for new registered entities, such as swap execution facilities and swap data repositories. The proposed regulation also prohibits event contracts based on certain excluded commodities, establishes special procedures for certain rule changes proposed by systemically important derivatives clearing organizations, or SIDCOs, and provide for the tolling of review periods for certain novel derivative products pending the resolution of jurisdictional determinations. I will address major changes to Part 40. With respect to the rule certification procedures, under the proposed rules, the Commission will have 10 business days to review a certification of a new rule or a rule amendment. Within 10 business days, the Commission determines that the submission involves a novel or complex issue or is submitted with an inadequate explanation or potentially is inconsistent with the Act, then the certification will be stayed for additional 90 days. The rule or rule amendment will be certified upon expiration of the 90-day review period unless the Commission objects to the certification. Under the proposed rules, if the Commission stays the review for additional 90 days, then the Commission will provide a 30-day public comment period. The Commission will provide notice of the comment by posting the notice and the rule submission on the Commission's website. With respect to certification procedures for submission of rules by CITCOs, the proposed regulations will require CITCO to provide the Commission with a 60-day advance notice of any proposed change to its rules or procedures that could materially affect the nature or level of risk presented by the CITCO. Under the proposed rules, changes that could materially affect the nature or level of risks are those as to which there is a reasonable possibility that the changes could substantially affect the performance of essential clearing and settlement function or the overall nature or level of risk presented by the CITCO. Such changes could include changes that materially affect financial resources, participant and product eligibility, risk management, default procedures, system safeguards, and governance. The proposed regulation would allow a CITCO to implement the proposed rule change the proposed regulation would allow a CITCO to implement a proposed rule change if the review period lapses without Commission action. The proposed rule would allow the Commission during the 60-day review period to extend a review period for additional 60 days if the proposed change raises novel or complex issues. With respect to event contracts, the proposed rules prohibit the listing, trading, or clearing of products that are based on certain excluded commodities and that involve terrorism, assassination, war, gaming, or an activity that is unlawful under any state or federal law. These prohibited activities are specifically enumerated in the statute. In addition, the proposed rule provides that if a product involves an activity similar to the activity prohibited by the statute, and if the Commission determines such product to be contrary to the public interest, then the product will be prohibited in a future rulemaking. If during the review of a new contract, the Commission determines that such product may involve any of the prohibited activities, the Commission will request that the registered entity suspend the listing or trading of the product and will conduct a 90-day review to determine whether the product violates the prohibitions on certain event contracts. Upon completion of its review, the Commission will issue a determination order. Finally, under the proposed rules, if a registered entity submits a product that may have elements of both a security and a derivative, the Commission or the SEC may request a jurisdictional determination from the other agency. If a jurisdictional determination is requested, the Commission will toll the applicable product certification or approval review period until the issuance of a final determination order. If the Commission or the SEC seeks judicial review of the jurisdictional determination, then the challenged order as well as the review period for the product will be stayed until the United States Court of Appeals for the District of Columbia Circuit issues a final determination. The review period will resume only upon a finding that the Commission has jurisdiction over the submission. That concludes my remarks. I'll be happy to take any questions.
The Chair will, thank you, Bella. The Chair will now entertain a motion to accept the staff recommendation and issue the proposed rules regarding Part 40.
Second.
With the motion made and seconded, I would like to open the floor to my fellow commissioners to ask any questions. I just have one, Bella, just to help to clarify for the public. In terms of these rules, as I understand them, we have a different approach for rule review than product review. The presumption, is that correct, that product reviews would only happen in a small set of circumstances, but rule reviews might happen in a more often?
That is correct. We have different procedures for product approval and product certification versus rule approval and rule certification. product certification procedures and product approval procedures remain largely the same. With respect to the rule approval procedures, we have this new requirement, and it applies to rule amendments as well. We have this new requirement of 10 and 90 days. I just want to to be clear that when a registered entity submits a contract that changes the terms and condition of a contract, it is considered to be a rule amendment, and therefore it has to follow the new rule amendment certification procedures for 10 and 90 days.
I see. But the goal of Congress was to give that these clearinghouse rules and maybe the designated contract market rules, we'd have 10 days. Most rules probably within the 10 days would not be novel or complex, and they would go into being.
That is correct.
And if staff then says that, no, there's something novel, complex, or in the systemically important clearinghouses, it might be a different term, material, then we have further review in that period, 90 extra days to review it. All right.
And with the opportunity for public comment during that 90 days.
Right. So that's a good point. So if we put it out for the 90 days, well, then we seek public comment by putting it right up on our website, getting public comment. You might want to hit your...
That's correct. If the Commission is going to stay the review period for 90 days, then the Commission will publish a notice on the website along with the submission. So it will be available.
And again, the presumption at the end of the 90 days is that the rule would go into effect unless the Commission determines by, majority rules and so forth, that it not go into effect.
That is correct.
Okay. I didn't have any further. I don't know, Commissioner Dunn?
Thank you, Mr. Chairman. Bill, could you describe for me the difference in the procedures that we are currently operating versus these proposed procedures on the timeline of implementing a new product?
For product or rule amendments or new rules. For products, the procedures, as I said, remain the same. We have, when a registered entity submits a new product for certification, this product will be certified within 1 business day. If a registered entity submits a product for approval, they follow the standard procedures that are currently in Part 40. The product will be approved within 45 days, or it may be extended if it involves novel or complex issues. With respect to rule certification procedures, this process is different from what we have currently in Part 40. Right now, under current regulation, when a registered entity submits a rule amendment or a new rule by certification, this rule will go into effect within 1 business day, one business day after it submits the submission to us, provide the submission to the Commission. This will change. Now, the Commission will have 10 business days to review the submission before it goes into effect. And as I mentioned, that many submissions will become effective within 10 business days. However, if the submission involves one of those novel or complex issues, then the Commission may stay the review for additional 90 days, and then the Commission will provide a notice of comment and post a notice on the Commission's website.
So in essence, then, on that procedure, we're going from immediate, the next day, to as long as 160 days? Is that?
I'm sorry, would you repeat your question?
For a rule, then, instead of being certified and going into effect the next day, it will now be at least 150 days or up to?
No, the rule will go in effect. Once a registered entity submits, once the Commission receives a certification, then the Commission will have 10 business days to review the submission. If the Commission determines that it's just this regular submission and doesn't involve any novel or complex issue and is complete, then the rule will go into effect upon the expiration of a 10 business day review period. However, if within 10 business days the Commission determines that there is a novel or complex issue or the submission is incomplete, then it will inform the registered entity that it will stay the review for additional 90 days. And after the expiration of the 90 days, if the commission doesn't act on it or doesn't inform the registered entity, the rule will go into effect unless the commission notifies otherwise.
Yeah, Commissioner Dunn, I think if what you're asking what the total review period would be, if for a submission that raises some novel issues, it would be the 10 business days plus the 90 days, so around 105 days or something like that, I guess.
Total of 100 days.
If that's what you're asking.
And how does that differ from our current procedure then?
Currently, the rule amendments and rule certifications are effective within 1 business day. So there is no 10 and 90 days.
Thank you.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. My questions are with regard to the review of event contracts, and if I understand correctly, the process for self-certification of event contracts, that they would follow the same procedure, that if you self-certify, they could go into effect the next business day as long as everything is in order. And my question is, what kind of review do we contemplate under 40.11 that would allow us the time to review an event contract within 1 business day?
Sorry. Currently, under Dodd-Frank Act, there are certain contracts, event contracts, that are explicitly prohibited that are going to be in Part 40. If the registered entity submits an event contract and in its opinion does not involve one of those prohibited activities, it will file a regular certification, it will follow the regular product certification procedures under 40.2. So during that, staff conducts review of certifications even though they become in effect within 1 business day. So if during that review the commission staff determines that one of those contracts may involve one of the prohibited activities, the staff then will request that the registered entity will suspend the trading of this contract and will conduct a 90-day review as required by Dodd-Frank Act. So within 90 days, if the commission determines that this contract is similar to one of the prohibited activities and is contrary to public policy, then the commission will issue determination and it will issue a rule prohibiting this type of the contract. So basically, for now, the procedure is going to be if a registered entity thinks that its contract does not involve one of the prohibited activity, then it will file under 40.2 regular certification procedure, and it will be staff responsibility to look for this contract and to see if they may be prohibited under 40.12.
Yes, because there's no specific statutory stay or whatever for these types of contracts. So presumably, if we get them in, those that are enumerated are pretty clear what they mean, and mostly. So I think the staff, we'd have to look at them and say, well, this potentially is similar to one of these. It raises a question. We would immediately get back to the exchange. It's most likely they wouldn't list it until this determination were made, but there isn't, as with the 10 and 90-day provision for rule certifications, there isn't a specific statutory provision for that. So it's something we'd have to work with the exchange. But typically, if exchange has a contract that they think is questionable, as we've seen in the past, they usually will talk to us in advance, and we'll have some notice about that.
I assumed that, but I guess I just had some concerns about whether we were comfortable with that 1-day review.
Really don't have
Fortunately,
much
Dodd-Frank doesn't give us the authority to place any sort of stay on the review.
Okay, thank you.
And just for the public, these enumerated items are terrorism, war, gaming,
assassination, any contracts that might violate any state or federal law.
So they're
all pretty clear.
Hopefully terrorism, assassination, these things are pretty clear to exchanges, but there may be some ambiguity from time to time. Anything, Commissioner Amalia? No, he didn't have any.
So I'm clear. If the movie guys came in under this language, and they weren't already previously banned, we would have to certify them in one day?
Well, the contract will go in effect, but certifying does mean approval. You know, the commission can come back anytime and ask them, you know, if we determine that there's one of the activities involves, you know, the prohibited activities, we can request them now under the new authority. We can request the registered entity to stop trading, and we'll conduct the review. And in my opinion, probably that will fall under the issue of whether this event contract is gaming or not, right? It's clearly not assassination or war. That will be the most controversial, I guess, issues to define what gaming is.
Yeah, and typically, as with those, the exchanges don't certify them and then list them immediately. They wouldn't want the legal uncertainty of not knowing what the commission's going to do. So even though I guess conceivably that could happen, our experience is that if they think there's any sort of a question, they'll be talking to the staff and the commission as to what they think this, you know, with respect to these new rules, whether they think they might violate them or the commission might have some concern with them.
So your recommendation to the event contracts entities, people who might be proposing event contracts, expect a 90-day review?
If it relates to some of those, anything that's listed in that list, it wouldn't be if it's, you know, something else, like it might be like a crop yield or something, you know, whatever.
And Rick, I understand, I think it's a very good question. I understand that today, or prior to Dodd-Frank, if one of the designated contract markets of the Chicago Mercantile Exchange, NYMEX, and so forth, had decided to do a movie future, they could self-certify in one day. You know, it was just because of the unique circumstance where somebody was coming in for both. They were both setting up a new exchange and doing a new product. Is that right?
That's right.
As they say, timing's everything.
Yeah, but now those are banned. Any other questions? There's a motion on the floor and seconded, so I'd like to if there are no further questions, thank the staff for their presentation. And I'm going to say I do support this rule. I'll have my little statement published in the Federal Register, but I support the rule. I think it does give market participants clarity on how we're going to do this. The Dodd-Frank bill set up the 10 and 90-day procedure, and in systemically important contract clearing organizations, 60 and 60. But I think the rule is excellently drafted, trying to give market participants clear procedures to do that. But I didn't know if anybody else wanted to say anything more.
No, just thank the staff who did a great job on this. Appreciate it.
So if there are no other views, all those in favor say aye.
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 Any opposed? The ayes having it, we'll send it along to the Federal Register. With that, I think we might have a swap out of some folks here. Adrian Jovez, I think, is going to present from the General Counsel's office with regard to credit rating agencies. As I understand, the Dodd-Frank Act, can't remember, it must have been Title IX, said that we had to stop relying on them in any of our rules. We had to first review our rules to see where we relied on them, and Adrian's going to tell us probably the 7 places we do that. And Adrian Jovez is assisted by Harold. Harold, you're not Dan. Harold Hardman, who is our Deputy General Counsel and has been tirelessly working on all of the rules because he heads up the regulatory piece of our General Counsel's office. Adrian?
Thank you, Chairman Gensler. Before I provide a brief summary of our proposal on credit ratings, I did want to recognize and thank our other team member, John DeBoard, who will shortly give you another proposal and another rulemaking, for all the efforts he contributed to our proposal that we're going to be discussing on credit ratings. I also wanted to briefly thank the other federal financial regulators who provided some very valuable feedback on this issue for us, especially the Securities Exchange Commission and the FDIC. Title IX of the Dodd-Frank Act, as you know, included findings that credit ratings are of systemic importance, and it also found that in the recent financial crisis, inaccurate credit ratings contributed significantly to the mismanagement of risk by financial institutions and by investors. As a result, Congress found that increased accountability on the part of credit rating agencies is necessary. Title IX contains several provisions that are designed to improve the accountability of credit rating agencies, including Section 939A. 939A requires all federal agencies to do three things. All federal agencies are required to review the regulations for any assessment of the creditworthiness of a security or a money market instrument, any reliance on that kind of assessment. It requires all federal agencies to remove those references and replace them with a substitute standard that the agencies deem is appropriate. And it third requires a report to Congress at the end of that process. Upon completing our required review of our regulations, we found 5 instances that contained references to credit ratings in relation to financial instruments. I'll briefly identify the regulations that we are proposing to remove those references to credit ratings and the substitute standards that we're proposing along with those. First, our required review identified 2 regulations that address in what foreign depositories future commission merchants and designated clearing organizations may place customer funds. Commission Regulations 30.7 and 1.49 currently permit FCMs or DCOs to place customer funds in foreign depositories that hold either in excess of $1 billion of regulatory capital or whose commercial paper or long-term debt instruments is rated in one of the 2 highest rating categories by at least one credit rating agency. We are proposing to amend both of those regulations in concert, albeit in 2 separate rulemakings. John is going to be discussing another proposal related to Commission Regulation 30.7 shortly. Our proposal for 1.49 includes removing the reference to credit ratings and substituting the standard that foreign depositories must hold in excess of $1 billion in regulatory capital. The proposal also requests comments specifically on whether a leverage ratio or a capital adequacy ratio requirement consistent with or similar to the standards that have been included in the recent Basel III Accords would be an appropriate additional standard to include in our regulations. Next, our review identified a third regulation that referenced credit ratings for financial instruments. Commission Regulation 4.24 requires commodity pool operators to disclose the type of commodity interest or other interests in which the pool will be trading, including by disclosing the investment rating of the pool's interests. We are proposing to remove the reference to investment ratings from 4.24 and replace it with the phrase creditworthiness. The proposal requests comment on this alternative standard. Finally, the last 2 regulations that we identified that contain some reference to credit ratings as they relate to financial institutions or financial instruments, will no longer make any reference to creditworthiness due to other unrelated proposed amendments that we are going to be noticing in other proposed rulemakings. As we mentioned a couple times, John DeBoard will be discussing the wholesale amendments to Regulation 1.25 that staff is going to be proposing. And as a result of those amendments, those proposals, there will no longer be any need to reference credit ratings in Commission Regulation 1.25. Similarly, the proposal that Bella just walked through on Part 40 contained a reference to the word rating in Appendix A, Guideline 1, as a way to help disclose the characteristics of certain contracts listed on DCMs. Because Part 40, the Appendix A to Part 40 will be removed in its entirety by Bella's proposal, we also don't have to make any change to that regulation in this proposal. Thank you, and I'll be happy to answer questions you have.
Thank you so much, Adrienne. With that, I'd entertain a motion.
So moved.
Second.
And then I just have one question because I keep thinking there were 7 references and you referred to 5, so my math has been faulty today. But
You were correct that there were 7 total references in all of our regulations that talked about any reference to credit rating. Dodd-Frank required us to look for assessments of creditworthiness related to securities or money market instruments. There were only 5 references in our regulations that talked about financial investments or those type of things.
I see. And between your proposed rule and John's proposed rule and maybe the Part 40 rule that we just voted on? Do we address all 7 or just 5 of them?
We addressed 5.
So there are 2 that we're not actually addressing?
The 2 we're not addressing are related to the creditworthiness of counterparties and not related to the types of investment vehicles or those kinds of things, which is required under Dodd-Frank.
I see. So the math, again, is there's 7 references, but through these 3 different rules today, we're addressing the 5 that the Dodd-Frank Act.
That's correct.
Thank you. Commissioner Dunn?
I have no questions on this.
Thank you. Seeing that there are no further questions, and I'll put a little statement in the Federal Register why I support it. If I could hear those all in favor, say aye.
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 Any opposed? The ayes being unanimous, we'll send yours along to the Federal Register as well for public comment. How many days public comment is yours?
We have a 30-day comment period.
All right, 30-day public comment period. On the first one, it was probably 60, if I have to get Rick. So the first one was 60 days public comment. Thank you. With that, we're going to move forward to the next rulemaking. So John is going to come up. I suspect there'll be a few more questions on this one. John is going to be ably supported by, I guess, his boss and his boss's boss or something, but Phyllis Dietz, who is also the team lead on the clearing rules, and Ananda Radhakrishnan, who runs the whole clearing and intermediary oversight division. John.
Good morning. I'm John DeBoard, the DCIO. I'm pleased to recommend that the Commission approve for publication in the Federal Register the Federal Register notice requesting public comment for proposed rules regarding investment of customer funds and secured amount funds under Regulation 1.25 and 30.7 respectively. I'm going to go over the background of the rule and then an overview of our proposal and then take any questions. Under Section 4D.A.2 of the Commodity Exchange Act, customer segregated funds may be invested in obligations of the United States, and obligations fully guaranteed as the principal and interest by the United States, essentially treasuries, and principal and general obligations of any state or any political subdivision thereof, municipal securities. In December 2000, and again in 2004 and 2005, the Commission amended Regulation 1.25 to include additional permitted investments such as GSE securities, CDs, commercial paper, corporate notes and bonds, foreign sovereign debt, and interest in money market mutual funds. Our amendments also included additional safeguards, such as credit rating requirements, issuer-based concentration limits, a requirement that all investments be readily marketable and sufficiently liquid, amendments regarding repurchase agreements, and certain requirements regarding in-house transactions, as well as other changes. In 2007, DCIO launched a review. The purpose was to learn more about the nature and extent of investments made by FCMs and DCOs. It was voluntary, but we received an overwhelming response from FCMs, and it was very helpful, and it helped shape our views that led to our proposal. As we were wrapping up in 2008, that review, we experienced a financial crisis. This also helped shape our views on the safety and liquidity of certain permitted investments during times of market volatility. In May of 2009, the Commission issued an ANPR regarding this topic, seeking public comment regarding regulatory requirements that might better safeguard customer funds. We received 12 comment letters, we reviewed them, and relied on them as well in formulating our proposal. As noted, this is not technically a Dodd-Frank rulemaking. However, there is a link to Dodd-Frank, as Adrian mentioned, which is the Section 939A requires the review and removal of credit ratings. As she mentioned, several references to credit ratings appear in 1.25 and 30.7. That's the background. Our proposal is as follows. First, I'm going to run through the list of permitted investments. First, we're proposing no changes to treasuries. We view them as safe and liquid, and we're not going to limit them in our proposal. We propose that municipals remain a permitted investment, However, due to liquidity and volatility concerns, we are recommending proposing a 10% asset-based concentration limit. That means that an FCM can invest a maximum of 10% of their total assets in segregation in municipals. Third, GSE securities. Currently, the term GSE securities incorporates two different types of entities. The first is a GSE, which is a privately owned and operated entity chartered by Congress. It has an implicit guarantee of the federal government. Examples might be Fannie Mae and Freddie Mac. The second is a public agency, a U.S. agency. U.S. agency is an entity of the federal government. It has an explicit guarantee. We're proposing to limit permitted investments into just U.S. agency obligations, the second type. We're also proposing a 50% asset-based concentration limit for those investments. CDs. CDs is another investment type that includes, for our purposes, two categories that we're going to distinguish between. The first is non-brokered CDs. The second is brokered CDs. Non-brokered CDs are what people typically think of when they think of a CD. An FCM purchases from a bank a CD. It has a maturity date, but if the FCM wants to redeem it early, it simply goes to the bank and redeems it. Any penalty is limited to a penalty involving the interest. A non-brokered CD, in my opinion, is a very different instrument. It's purchased in a large size by a broker. It's then sliced up and sold individually to purchasers. If the purchaser chooses to redeem early, it cannot go directly to the bank. Its only option is to go into the secondary market, which can often be illiquid. We're therefore proposing to limit CDs to just the non-brokered CDs. We're also proposing a 25% asset-based concentration limit for that investment. Commercial paper and corporate notes and bonds, we're proposing to limit those to only commercial paper and corporate notes and bonds that are guaranteed by the Temporary Liquidity Guarantee Program as administered by the FDIC. Commercial paper, we're proposing that commercial paper have a 25% asset-based concentration limit. We're also proposing that corporate notes and bonds have a 25% asset-based concentration limit. We're also proposing to eliminate foreign sovereign debt. First, over the last few years, it's experienced, in certain instances, volatility. And second, it's a negligibly used instrument by FCMs. Eighth, money market mutual funds. We're proposing to maintain money market mutual funds as an investment under 1.25. However, due to safety and liquidity concerns during periods of market volatility, we're proposing a 10% asset-based concentration limit. We're also proposing a 2% issuer-based concentration limit for families of funds. Additionally, 5 of those permitted investments, CDs, corporate notes and bonds, commercial paper, municipals, is that 5? What's that? And GSEs, agencies, all have certain requirements regarding credit ratings. As Adrian mentioned, we're proposing to eliminate all of those. A few other notes regarding 1.25. We're proposing to eliminate in-house transactions. We're proposing to eliminate repurchase agreements with affiliates. We're proposing a 5% counterparty concentration limit for repurchase agreements. The situation we're trying to avoid there is where a FCM engages in a reverse repurchase agreement, takes 100% of its cash into a repo, and then the counterparty defaults. This would limit that to a 5% counterparty concentration limit to help safeguard against that situation. There are additional technical amendments to 1.25 I can discuss if you want me to. 30.7 regards U.S. customers investing in foreign futures. Currently, there's not an enumerated list of investments that those customers are limited to. Rather, there's a more general obligation to invest in only liquid investments that are sufficient to meet obligations to customers. We're proposing today to limit 30.7 funds to the investment limitations of 1.25. We also, as Adrian mentioned, are proposing to eliminate references to credit agreements, along with a couple of other technical amendments to 30.7. That concludes the overview. Thank you, and I'm happy to answer any questions.
Just to add one point, 1.25 goes towards what an FCM and a DCO can do once it gets money or securities from a customer. Is what are you allowed to do with the assets that you get from your customers? 1.25 does not go towards what an FCM can take from its customers. That is usually guided by exchange rules. For example, the CME, for example, has a rule that it directs to its member FCMs as to what it is they can accept from their customers. So I just wanted to make it clear to the Commission that this applies. Once you get some money in, what can you do with it?
Thank you, John and Ananda and Phyllis, supporting. With that, I'd entertain a motion to accept the staff's recommendations.
So moved.
Second. With that, some discussions. I just start on Ananda. What you just said, as I understand it, this is only if that Futures Commission merchant or the clearing organization takes cash, what it can do with the cash. Is that what you're saying?
Either cash or any other type of collateral that it allows to accept. For example, a customer may give treasuries to an FCM, and we're proposing to allow them to engage in, you reverse it out, reverses. We can do repos.
But if the exchange allows them to take what I'll call a non-permitted asset here, this rule won't force them to.
Correct. It will not.
They can do that.
Sure.
So if the exchange says you can take municipals or corporates or
Correct.
money market funds greater than the 10%.
Correct.
They can continue to do that.
Correct.
This is basically,
Once
what do
you-
you do with your?
Once you bring it in, what can you do with it? Once the FCM accepts something from a customer.
Right, but basically that's cash then. That's what
Yeah.
you can invest. The other thing, a question for John is, so I understand that there's sort of five, maybe it's five, I might have counted wrong. I've been counting poorly today. But that there may have been 4 or 5 areas where we had to address this because it relates to ratings, rating agencies on sovereign debts, rating agencies on municipals. That's how we find ourselves in this position. Is that correct?
That's correct.
And in some instances, like sovereigns, you say there's such negligible use of it currently. You just said, all right, we don't have a ready alternative to ratings.
Right. And the other issue with sovereigns is you've got 2 risks. You've got liquidity risks and you've got currency risk as well. Plus, you've got
But
these-
nonetheless, we don't have a good alternative
We do not
to
have a good
rating
correct.
agencies.
We
So your staff recommendation is that it's not used that much.
Correct.
But then getting to an area where Commissioner Amalia spoke to, and I think it would be supportive of this proposal, and it's just that, a proposal, but I think the public should comment on, is why did you decide to limit, let's say, money market funds to 10%? I think Commissioner Amalia raised.
A big concern was with a significant money market fund called the Reserve Fund, which broke the buck. That was described as a government money market fund, but as we found out, government funds that are described as government money market funds do not necessarily have to invest all their money in government securities. So that fund had significant holdings of layman commercial paper. One of our rules said that if you want to be a money market fund that wants to participate in our program, you've got to allow for next day redemption. The SEC rules allow for 7-day redemptions, but we said that's nice. You want to participate in our rule, you must allow for next day redemption, and your offering documents have to show that. 2 things happened. That fund broke the buck. It applied to the SEC for a waiver of the next day redemption rule. In fact, the SEC, I think, said you don't have to redeem it. So we were left with a situation where FCMs had significant investments in that particular money market fund, and there was a lot of confusion as to when that fund was able to return money to customers. And we were working on a daily basis with staff at the SEC, basically to find out the answer. When is this fund going to pay customers back, and also how much is it going to pay back? As I said before, I guess this was an issue that hadn't confronted the SEC staff for some time, so there was a lot of confusion. It was clear that the value of that fund was not zero. The net asset value was not zero because they had a lot of investment. The issue was what was the value and when could you realize it? And eventually, we had to make decisions as to how to value that fund, and we issued an interpretive letter that basically had a graduating scale downwards towards where we said, after a particular point in time, value it at 90 cents to the dollar. And that was based on the value, the market value of investments that the fund did have, which were not underwater. The layman stuff, zero value, but the rest of the stuff, there was some value. And finally, there was a resolution, and I think people got more than 90 cents to the dollar. But the object of the story is, once what people thought were very safe investments are not necessarily so. And to our knowledge, there is no government guarantee. I know there was a temporary guarantee program of money market funds, but to this day, we are not aware of any money market fund that has a guarantee of that nature. So basically, we want to make sure that these are investments that other people make for customer money. And I think that needs to be borne in mind. This is not what the customer tells you to do. This is what the FCM and the DCO does with customer funds. And our regulations permit FCMs and DCOs to keep the spread. They're not obliged to give that earnings back to the customer. So we want to make sure that investments of customer money is made in very safe, very liquid instruments. And that's why we're proposing the limitation to on money market funds.
I would also just add, putting this into a broader context, there is an overarching requirement that the FCM or DCO invest with the objective of preserving principal and maintaining liquidity. And technically, the Reserve Primary Fund met all of the requirements of 1.25. It had next day redemption. It was a 2A7 fund. There was nothing wrong with the investment. But as it turns out, it didn't meet the overarching requirements. And liquidity is particularly important. And we just made a judgment as to what we thought an appropriate threshold would be for what we now understand to be the nature and characteristics of money market mutual funds at this point.
And I think that you include, or we, if we adopt this, but you've included, I can't find it, so if you can confirm, do we have a specific set of questions about money market funds? I mean, we say we request comment on whether money market fund investments should be limited to treasuries or those, et cetera, et cetera. But do we actually specifically ask about this 10% limit? We do. Okay, we do. I have one other question that came up, and I didn't follow the discussion on GSEs. I understand that GSEs are not guaranteed by the government and all that. But what is the limit that's in the rule? Maybe it's off of Commissioner Maly's question, but what are we saying specifically on GSEs?
You asked about the asset-based concentration limit for the asset-based concentration limit for U.S. agency obligations is 50%. There's already there's already a 25% issuer-based limitation. So, at most, an FCM could have two 25% investments totaling 50% in U.S. agency obligations.
Oh, so it's not that we have a 50% limit. It's just that you're saying that we have a 25% limit, and because there's two Fannie Mae and Freddie Mac?
No, that's not true. We are actually proposing a 50% limit. Right now, under current law, there is no limit. So 100% of your investments can be in GSEs. What we're proposing two things. These entities, GSEs, government corporations, they must be fully, explicitly backed by the full faith and credit of the United States for principal and interest.
They're not.
That's right. So there is one, Ginnie Mae.
There are, yeah.
The important distinction is between GSEs, which are private entities, and U.S. agencies, which are entities of the federal government. The first have an implicit backing of the United States. So Fannie Mae and Freddie Mac are not actually explicitly guaranteed. U.S. agencies like Ginnie Mae, Small Business Administration, are federal entities. They are explicitly backed by the full faith and credit of the United States. That's the distinction that we made. On top of that, we added a 50% asset-based concentration limit, and there's a 25% issuer-based
And so,
concentration limit.
Commissioner Malia, because we're allowed to deliberate, you're thinking that it should be less than 50%, just so I can learn from what you're thinking?
No, I think these rules are overly prescriptive, and we have a limit of 10% on money markets. We have a 50% limit on these GSEs, but only one GSE actually qualifies. So we're you're allowed to put 50% of your money into one entity.
You're talking about
based on Ginnie Mae, I believe.
True, but on the flip side, that entity is explicitly backed by the full faith and credit of the United States government.
I see.
Why don't we just put it all in Treasuries and Ginnie Mae and just get over it? Money markets are, I'm concerned that you're saying that money markets are not someplace where people should put their money anymore.
Without also, sorry.
I don't think we're saying that.
I
I don't think we are saying. I think what we are saying is that.
This may be news to the Fed, by the way.
I think what we are saying is, what you want to do with your own money is your business. But if you're investing other people's money, it has to be safe and liquid, and that's the overarching message. Because the time when you need it the most, as we saw in 2008, there's a flight to quality, and that's when you have issues. And we want to make sure that in a time when FCM or a DCO needs to get access to, this is essentially margin, right? This is margin, that there be the instances in which unfettered access to liquid assets, that there's a minimization as to when there's a barrier.
But so, as I understand it, and I find myself, I'm voting for this rule. I sense you might not be, but it's a proposal, so we'll get comments. Is that very interested in the public's views on this 10% limit.
Right.
It's really that which is the GSE thing, now that we've clarified, that's just that Ginnie Mae can be up to half the portfolio.
Right.
That's not Fannie and Freddie.
No, it's not Fannie and Freddie, because Fannie and Freddie are not explicitly guaranteed. Now, the reason we left a reference to GSE, there might be in the future, federal government may decide to explicitly back the debt instruments.
No, but they have it now.
But they have it now. That's right. And we admit that there isn't one now.
Phyllis?
I would just like to clarify on a couple of points. As far as GSEs, government-sponsored enterprises, that was a term that we used and use currently. And we have become aware now, since the Fannie and Freddie problems, that there are two different types of agency securities, as John mentioned. There are U.S. government corporations, like Ginnie Mae, and then there are technically GSEs that are Fannies and Freddies. And there is actually, in I believe it's Title 31, an enumerated list of U.S. government corporations. And the idea is there is a 50% limit on U.S. government agency, what we're calling agency securities, that are backed by the full faith and credit of the U.S. So as Ananda said, that's only the Ginnie Mae types corporations, but we include within the definition GSEs. So at such time as we don't have an implicit but an explicit guarantee, if that should happen, those would be encompassed within our regulation. We don't have to go back and amend it. There is, however, a 25% issuer-based concentration limit that exists today. We're not changing that. So indeed, even though up to 50% of a portfolio of total assets in segregation could be in these government agency securities, only 25% of total assets in seg can be in securities of one issuer. So there are two different types of concentration limits. There's issuer-based, and that which goes to credit risk, and then there is asset-based or instrument-based, which goes to the category of investment. So, for example, with money market mutual funds, there is a 10% asset-based limit, which would apply to total assets in seg, any money market mutual fund, and then there is a 2% issuer-based limit related to family of funds. Is that just to clarify?
I think I understand enough. I'm as I say, I'm supporting the rule. I think Commissioner Dunn sometimes says that it's more liberal when you're supporting proposals. I think this is a necessary rule because of the credit rating piece. There's like 5 or 6 places that we have to, in essence, clean up 1.25 for that reason. In addition, I think it's appropriate to address ourselves to what happened in the 2008 crisis around government-sponsored enterprises and money market funds. My question, similar probably to Commissioner Amalia, is whether 10% is too tight, but we'll hear from the public. Commissioner Dunn?
Thank you, Mr. Chairman. I think that safeguarding a customer's funds is one of the basic functions of the Commodity Futures Trading Commission, and I applaud the staff for their actions in this area. I have some concerns very similar to Commissioner Amalia's on the limitations, and I'm wondering, John, do we have an idea of how much is currently invested in this in these various categories?
Our 2007 survey addressed that, although it's been 3 years since then. Certainly there were some that were negligibly used. As I mentioned, foreign sovereign debt, barely used at all. It seems like treasuries and money funds were the 2 largest categories, and then, frankly, not very much in municipals, minimal amounts in commercial paper and corporate notes. I think just from anecdotally, I think there's a larger percentage in CDs now than there was a few years ago. But that's just anecdotal. So I don't have set figures for you, more just my impressions.
No, that's correct.
So it's very difficult for us to determine.
Basically cash, treasuries, money market funds, and there's some agencies, but the others weren't that heavily used.
But it's very difficult for us to determine if these are high or low or just right, because we really don't have a handle on how much are currently invested in these various asset classes. One other thing I'd like to bring out on the GSE, and it's 2 GSEs that are very near and dear to my heart, Farmer Mac and the Farm Credit System. And it's my understanding if we adopt this proposed rule as is, they would not be eligible classes for investment.
If they're not, if their debt, that the issue is not explicitly backed by the full faith and credit of the United States, then they would not be eligible.
Again, this for municipalities and others, I mean, this falls in the realm of unintended consequences, and I would hope that the commenters on here give us some type of insight as to what the effect of this proposed rule is. As the chairman said, I'm liberal on proposed rules. I look forward for the public to give us comments, the industry to give us comments, to help us direct these final rules that will ensure that we safeguard the customer's fund, because I think that's paramount, but to make sure that we're not doing something else that will have some impacts that we would not like to follow. Thank you.
I think Phyllis was about to speak.
Yeah, I just wanted to add that I'm looking through my draft now, but we did do the advance notice of proposed rulemaking. So we did get some more up-to-date data, and I think that the consensus was that the investments were mostly in treasuries and money market mutual funds. And I can't find my place right now, but we do have some more up-to-date data. Also, the survey that we did at the end of 2007, I think, is still useful in that it reflects a more normal and stable market situation. So there were dramatic changes, of course, after September 2008, and presumably slowly but surely people are resuming, normal investment practices. So I think that even though we don't have empirical data as of today, I think we have a pretty good sense based on our survey, based on the comments we got on the AMPR, and based on filings that we get from our from our FCM registrants and questions also that I get informally, phone calls asking questions about permitted investments. So we have a pretty good idea of what people are investing in.
Commissioner Summers.
Thank you, Mr. Chairman. I have a question with regard to what I understand may have been a change in Section 627 of Dodd-Frank to remove the prohibition on payments of interest on demand deposits. And I was just wondering what kind of impact that change may have had on decisions that you made for what is permitted or not permitted in the future.
I think certainly that did have some influence, because historically the reason why nobody parked cash because you couldn't get interest, right? Because we said when you park cash, it has to be in a demand deposit account, and there was the prohibition against paying interest on demand deposit accounts. So if we see as a result of Section 627 the allowance of paying interest by commercial banks to pay interest on demand deposit accounts, you might see a move towards money being put in demand deposit accounts. Although, given the interest that's currently being paid on demand deposit accounts, there may be some sort of reluctance. But that certainly would have a bearing. For example, if you look at in the UK, after Lehman, there was a huge move towards cash. Because in the UK, they've never had this prohibition. And at one point, the London Clearinghouse staff told me that they had 25 billion euro in cash because people were not trusting any other form of instrument. Now, that's changed since then. So there might be a move towards cash.
I guess my question was more as to whether interest on demand deposit accounts could be seen as a substitute for anything that we are now prohibiting.
It could be. Well, I don't think so, because I think if you look at interest rates, it may be a substitute for CDs, because you don't have, assuming that a CD had a penalty and early withdrawal of the interest. So people might put money in demand deposit accounts instead of CDs. But I believe historically the other instruments tended to pay a better rate of return than demand deposit accounts. But on the other hand, there might be people who, because of the perceived, because of the liquidity and the safety of demand deposit accounts, put money in demand deposit accounts.
I have one other question. The chart that you're working off of, is this included in the proposed rule? And I guess I'm wondering if it could be posted with the proposed rule?
We had actually just done that just to, as an aid for the commissioners.
I think it's really helpful.
Yeah, we can put it on the website. Sure, okay. Sure. Thank you.
Thank you. I think it's a good suggestion on putting that on the website. Commissioner Chilton?
I don't have any questions. Thank you.
Commissioner Amaya, adding to our colloquies.
Yeah. For us growing up on a farm, there's an old saying, there's no second education in the kick of a mule. Or there's no education in the second kick of a mule, actually. And I'm a little frustrated with this rulemaking because we did do an advance notice of proposed rulemaking, and we did receive comments that said, we put it in Treasury, put it in mutual fund, money markets. And we completely ignored that. I think that if we've done anything, I hope that Dodd-Frank has at least restored some stability to our banking system and the financial integrity therein. And I do believe that your analogy, Ananda, was fine. It was a real concern. That was a problem. That was a breakdown in our financial system. After 2,000 pages of Dodd-Frank, I hope we fixed that. And I think we should be able to put money back in that, and I think we ought to raise these numbers significantly. And I'm just going to leave it at that.
If I might, and I can't remember our procedures, I'd like to propose one amendment and see if I have support, but it's an amendment to have an explicit question, because I just can't find it on page 17, but have an explicit question about the 10% limit on money market funds, and to have a variation on it to say, so one, is this the appropriate level given the events of 2008 and the passage of Dodd-Frank? And secondly, that if not, what other level might be appropriate? And thirdly, that if it was at a higher level, might there be limits per mutual money market, but per issuer?
Issuer base.
Issuer base,
So what,
you know.
so what would be the appropriate
Yeah,
level?
yeah. And I mean, if it's some other number other than 10%, maybe there's some set of issuer-based. So I'd like to offer that as an amendment. It's really just questions, but important questions, and I think I have to see whether there's a second to my amendment.
Second.
So now I'm going to take a vote on the amendment, and then I'll take a vote on the underlying rule. So first, a vote on the amendment. All aye.
Aye.
Any opposed?
Aye.
Yes. And now on the underlying rule as amended, all in favor say aye.
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 Opposed? So I think it's 4-1 on the proposal sending to the Federal Register as amended, and I thank you all. And it's very helpful. I mean, and this debate is very helpful, too. I thank you, Phyllis and John and Ananda. And then I think we're turning to the fourth rule set. Eileen Donovan of the Clearing and Intermediary Oversight will now present proposed rules on the process for swaps to be determined to be mandatorily cleared.
Good morning.
Good morning, Eileen and Ananda.
The staff is recommending that the Commission approve for publication in the Federal Register a notice of proposed rulemaking on the process for review of swaps for mandatory clearing. The rulemaking is divided into 4 parts. The first part concerns the eligibility of a DCO to clear swaps. Section 745B of the Dodd-Frank Act directs the Commission to prescribe criteria, conditions, or rules under which the Commission will determine the initial eligibility or continuing qualification of a DCO to clear swaps. Under the proposed rule, a DCO would be presumed eligible to accept for clearing any swap that is within a group, category, type, or class of swaps that the DCO already clears. A DCO that plans to accept for clearing any swap that is not within a group, category, type, or class of swaps that the DCO already clears would be required to request a determination by the Commission of its eligibility to clear the swap. To receive such a determination, a DCO would have to file a written request with the Commission that addresses its ability to maintain compliance with the DCO core principles if it accepts the swap for clearing, in particular the sufficiency of its financial resources and its ability to manage the risks associated with clearing the swap, especially if the Commission determines that the swap is required to be cleared. The second part of the rulemaking concerns submission of swaps to the Commission. Section 723A3 of the Dodd-Frank Act provides that it shall be unlawful for any person to engage in a swap unless that person submits such swap for clearing to a DCO that is registered under the CEA or a DCO that is exempt from registration under the CEA if the swap is required to be cleared. Section 723A3 requires the Commission to adopt rules for the review of a swap or group, category, type, or class of swaps to make a determination as to whether the swap should be required to be cleared. The proposed rule requires the DCO submitting swaps to the Commission to provide certain information to assist the Commission in its review, including a statement that addresses the 5 specific factors that the Dodd-Frank Act requires the Commission to take into account when reviewing a swap submission. Those 5 factors are, first, the existence of significant outstanding notional exposures, trading liquidity, and adequate pricing data. Second, the availability of rule framework, capacity, operational expertise and resources, and credit support infrastructure to clear the contract on terms that are consistent with the material terms and trading conventions on which the contract is then traded. Third, the effect on the mitigation of systemic risk, taking into account the size of the market for such contract and the resources of the DCO available to clear the contract. Fourth, the effect on competition, including appropriate fees and charges applied to clearing. And finally, the existence of reasonable legal certainty in the event of the insolvency of the relevant DCO or one or more of its clearing members with regard to the treatment of customer and swap counterparty positions, funds, and property. The DCO would also be required to provide a description of the manner in which the DCO has provided notice of the submission to its members and a summary of any opposition expressed by members. As required by Dodd-Frank, the submission would be posted for a 30-day public comment period, and the Commission would make its determination no later than 90 days after receiving a complete submission unless the DCO agrees to an extension. The third part of the rulemaking concerns Commission-initiated reviews of swaps. The Dodd-Frank Act requires the Commission on an ongoing basis to review swaps that have not been accepted for clearing by a DCO to make a determination as to whether the swaps should be required to be cleared. If no DCO has accepted for clearing swaps that the Commission finds would otherwise be subject to a clearing requirement, the Commission would investigate the relevant facts and circumstances and within 30 days of the completion of its investigation, issue a public report containing the results of the investigation. The Commission would take such actions as it determines to be necessary and in the public interest, which may include the establishment of margin or capital requirements for parties to the swaps. And finally, the last part of the rulemaking concerns the stay of a clearing requirement. After making a determination that a swap is required to be cleared, the Commission, on application of a counterparty to a swap or on its own initiative, may stay the clearing requirement until it completes a review of the terms of the swap and the clearing arrangement. If the Commission decides to issue a stay, it would have 90 days to complete its review of the clearing of the swap, unless the DCO agrees to an extension. Upon completion of its review, the Commission could determine, subject to any terms and conditions as the Commission determines to be appropriate, that the swap must be cleared or that the clearing requirement will not apply, but clearing may continue on a non-mandatory basis. Thank you, and I'll take any questions you have.
Thank you, Eileen. I'll entertain a motion.
So moved.
Second, with the motion properly made and seconded, just a couple of questions. As I understand, Eileen, I support this proposal. I think it's a very important process rule. But as I understand it, we earlier, under Dodd-Frank, asked each of the clearing organizations that currently clear swaps to wait a little while until their swaps are submitted under this process. Can you walk us through, either Ananda or you, just walk us through how that relates to this rule?
Sure. Swaps that are already being cleared are deemed submitted to the Commission for review, so therefore the Commission has 90 days to review those swaps unless the DCOs agree to an extension. We requested that all of those DCOs agree to an extension, and they did agree, so that once these rules become final, which we're hoping will be in April, the Commission can begin its 90-day review of those swaps, meaning a determination on the clearing requirement could be made by July, which would be the effective date of the legislation.
And if I remember, I think there were 8 or so.
There's 8 DCOs that currently clear OTC products that may or may not be swapped.
So those 8 clearing organizations, under the statute, it was deemed that they were submitted unless they agreed to an extension. They've all agreed to an extension, all 8.
That's correct.
And the goal of staff, one that I endorse, is that we try to complete this rule before the 360 days, but complete it in 270 or so days by next April 15th, tax day. I think it's also Pete Rouse's birthday. But by tax day, so that we can run the 90-day process. Is that what your thinking is?
Yes, that's correct.
Okay. Thank you. I don't have other questions. Commissioner Dunn?
I have no questions on this. I think the taxing point is the staff and the Commission to be able to do these reviews.
Commissioner Dunn, I agree with you. In terms of just some of the figures, we don't know how we'll group these, but the largest interest rate swap clearinghouse right now, LCH, in some discussions with them, they have in the interest rate space, I think nearly 750,000 contracts that they clear, and some of their non-interest rate, it adds up to about 1 million. Is that right, Ananda?
Yeah, that's correct.
Presumably, it will be grouped by class and so forth. But next spring, we might be putting out to public comment this nearly 750,000 interest rate swaps that they currently clear. Hopefully boiled down to hopefully dozens of categories. But I share your views. Without staff, it's going to get clogged up pretty fast. Commissioner Summers?
Thank you, Mr. Chairman. Just to walk through that type of example that he used with LCH, if you could, LCH or another clearinghouse that may want to clear interest rate swaps applies to clear a class of swaps and tells the Commission that they intend to clear 300,000 different interest rate swaps. What is the process for that from our point of view?
Well, each of those swaps have to be submitted, but there is a provision in the rule that requires that to the extent that they can do so, that they group them by class, type, or category, and it also gives the Commission the right under the rule to group those appropriately for review.
And if they submit them as a group, then from our point of view, the process is to go through 300,000 different interest rate swaps. Do we then make determinations that 200,000 of them are okay, but 100,000 of them are not? How?
That's possibly, that could be a possible outcome. Although I would think that without prejudging the issue, if a clearinghouse is already successfully clearing swaps, then we would have to, staff would have to have good reasons to recommend to the Commission that, let's say there's 300,000, 200,000, 100,000 either shouldn't be cleared or there should not be a determination that they should be cleared. But, Commissioner Summers, you are pointing to the enormity of the task, and I will not tell you otherwise. It is an enormous task. So it could be that one group is U.S. dollar-based, fixed, plain vanilla, fixed for floating. You know, the floating is LIBOR, but the fixed rate is, you know, it depends on the day, and it's 5-year swaps. So that could be easier to evaluate. But we will really know what our task is once we start evaluating them. And then hopefully the public comment period will help the Commission, help the staff in making a recommendation to the Commission.
That was my next question, really, is then for final rules in this area, do we expect that there will be more specific information about exactly what the process is going to be and how, especially in a situation where you may have a clearinghouse that already clears a million different contracts and interest rate swaps, but a new clearinghouse that wants to clear the exact same. What's the process of deciding whether or not that new clearinghouse is eligible, or how do we decide? You know, will there be more substance in a final rule?
Well, a new clearinghouse that wants to clear would first have to go through the first part, the review of their eligibility to clear swaps under 745B.
I guess I was just assuming that had a new clearinghouse that has already been approved to clear.
To clear swaps or just a new DCO? I think what Eileen is talking about is if a DCO hasn't started clearing swaps and wants to clear swaps, then he'll have to apply to us under these rules to say, why is it eligible to clear swaps? So basically, he'll tell us what does he want to clear, what his margining regime is, what its ongoing risk management is, what his default procedures are. Basically, a demonstration to the Commission that it is qualified to clear a particular class of swaps.
That approval will be by asset class for new DCOs?
Yes, potentially it could be by asset class, yeah. It depends on what it is they want to clear.
Okay, I'm sorry. I have one other question regarding the stay. And if you could explain what a reason would be for a counterparty to apply for a stay, and what would be a reason that we would grant a stay to a counterparty?
The rule doesn't go to that. We just ask that they provide an explanation of why. I mean, I think the presumption would be that it would be one of those 5 factors that I listed, that for some reason the Commission's decision on any of those factors, that the counterparty is disputing the finding on those. I mean, we could ask that in the proposal, or, you know, it's possible based on the comments we get in response to the proposal that we would refine that in the final rule.
And then the determination or approval of that stay would have an effect on all other swaps of that category? If a particular counterparty applied and said they requested a stay, that stay would be applicable to that class?
Right. All swaps that fall under that requirement, yes.
I thank Commissioner Summers. I think just it highlights, and I believe, and I can only speak one commissioner, I believe that the only way this is going to work if it's done by class or group of contracts. There's no way. We don't have the resources, nor does the public through a 30-day period. LCH, for instance, currently clears interest rate swaps for a group of currencies. Let's say that's 15 or 20 different currencies. And Ananda used the example of U.S. dollar swaps, that they would somehow submit to us their U.S. dollar swap business, maybe broken down by 3 or 4 or 5 or maybe 10 or 20 categories, but not the hundreds of thousands of contracts. I think that's the only way we can do it, and I think it's the best way for the public to react. But I can't predict how they'll submit it. They could submit next April in a way that we ask them. I think under this rule, we could ask them to recategorize, right? This gives us permission to regroup and recategorize.
Yes, it does.
And it's correct that if it were approved for one swap house, clearing house, it relates to others. If there is another eligible interest rate clearinghouse, they too would be able to do it. Is that right? I mean, once you're eligible in that category?
Once you're eligible in that category, once you've already been approved to clear interest rate swaps, yes.
Right. So we're not trying to pick amongst them, even though
No.
both Commissioner Summers and I use them as an example. We're
Right.
not trying to pick amongst
Correct.
them.
Correct.
Commissioner Chilton, Commissioner O'Malley. Not having any further questions, I'll call the vote. All in favor?
Aye.
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 Any opposed? It being unanimous 5-0, I thank Eileen and Ananda, and we'll send it off to the Federal Register. And so what do we have next? Bob. So we have one proposed rule and one proposed set of questions called an advance notice to proposed rulemaking on anti-manipulation and on disruptive trading practices. So I'll only introduce you once. Bob Peace has been the team lead with Mark Higgins, but they're going to be assisted by Vince McGonigal, who is the acting head of the Division of Enforcement. And you're not Ananda, but you're Brad Berry, who's Deputy Director of our General Counsel and heads sort of our appellate litigation there. So, Bob, or whomever is taking the lead on this one.
Sure.
Mark.
Good morning, Mr. Chairman and Commissioners. Section 753 of Dodd-Frank amends Section 6C of the Commodity Exchange Act. The team presentation today is to propose anti-manipulation rules concerning two subsections of Section C. New Section C1 expands the authority of the Commission to prohibit any person from using or attempting to use any manipulative or deceptive device or contrivance. Section C1 is patterned after Section 10B of the Securities and Exchange Act of 1934, which courts have interpreted as a broad, anti-fraud catch-all designed to reach intentional or reckless misconduct that deceives or defrauds market participants. New Section C1 is also similar to anti-manipulation authority granted to the Federal Energy Regulatory Commission in 2005 and the Federal Trade Commission in 2007. FERC and the FTC implemented their authority by promulgating rules based on SEC Rule 10b-5 with appropriate modification to their regulatory missions. The first of two proposed rules before you today under Section 753 are also modeled on SEC Rule 10b-5 with tailoring that reflects not only the distinct regulatory mission of the CFTC, but also the CFTC's own experience and precedent policing market manipulation and fraud. In Section 753, Congress also created a new Section 6C titled Other Manipulation. The second proposed rule before you today mirrors the text of new Section 6C3. The purpose of this rulemaking is to affirm certain legal principles relevant to the CEA's prohibition against price manipulation of any swaps or any commodity in interstate commerce for future delivery. Separately, Section 753 also provides for a prohibition on manipulation by false reporting that affects or tends to affect the price of any commodity. This provision is entitled Special Provision for Manipulation by False Reporting, and no rulemaking is needed to implement it. Section 753 also protects against good faith mistakes that result in false or misleading or inaccurate information being transmitted to a price reporting service. 753 also prohibits any person from making any false or misleading statement of material fact to the Commission. As with the false reporting provision previously mentioned, no rulemaking is needed to implement this section. Finally, Section 753 expressly preserves the applicability of the anti-manipulation provision found in CEA Section 9A2. Last, as stated in Section 754 of Dodd-Frank, the prohibitions in Section 753 that require no rulemaking will become effective 360 days after the date of enactment of Dodd-Frank. The proposed rules before you, should they become final rules, will be effective 60 days after the final rules are published or 360 days from the date of enactment, whichever is later. In the course leading up to this proposed rule, we received one public comment. Before concluding my presentation, I would be remiss if I did not acknowledge the individual contributions of Assistant General Counsel Ralph Avery, Counsel Mary Connolly, and Enforcement Attorney Brian Walsh to drafting these proposed rules, as well as the outstanding administrative support of Yolanda Smith and the leadership of Bob Peace. That concludes my presentation.
Thank you, Mark. I'll entertain a motion on the staff recommendation on the rule related to manipulation. It's one rule, right? You mentioned two, but it's really one.
Under 753, there are two rules, one under subsection C1 and one under subsection C3.
Does that mean I need two motions and two votes?
No, they're contained within one document.
Okay,
so
one. All right, thank you. Entertain a motion on...
So moved.
Second?
With discussion, I just had one question, and sorry I didn't have you prepare for this one, but when you mentioned the SEC's Rule 10b-5 and their statutory provision 10b, you remind me of insider trading, that is how over at the SEC in many cases have been brought. And could you just walk us through how you've addressed that here and so forth?
Right. The CFTC, as you well know, does not have a prohibition on insider trading. So a market participant that is trading or hedging their crops or their expected production would still be able to continue to do so. The rule does not upset any of the Commission's longstanding precedent in that regard.
And is that because the SEC put that in a Rule 10b-5 and you've not done that here?
That is true. 10b-5-1, I believe, is a specific prohibition on insider trading. But more fundamentally, the SEC's regulatory mission is about disclosure, and part of that is not allowing market participants to trade on insider information. We're about protecting the integrity of the markets, recognizing that for people to hedge and for price discovery to occur, people will be trading on knowledge that they have that's not public.
So I'm going to just say I'm going to support this proposed rulemaking today. I think that it really helps the Commission broaden our ability to police markets, as the statute says, to make sure there's fair and equitable trading. Congress granted the Commission this authority in addition to the disruptive trading practices authority. I think this brings new, under the first half of it, what you called the first rule, to police for fraud-based manipulation, whereas the Commission has had, I guess you'd call the other one, price-based manipulation in the past. And I also would be remiss without thanking Senator Cantwell for her leadership, and she worked with Senator Lincoln, I know, on making sure this was part of our statutory regime. Commissioner Dunn?
Thank you, Mr. Chairman. I greatly appreciate seeing this as part of the Dodd-Frank Act and the Commission acting on this. I share the frustration of my fellow Commissioner Chilton in his opening remarks. It oftentimes looks to us that things are very apparent, and when we get into the case law and to determining what is manipulation, we find that our hands are often tied. I think this goes a long way in helping our enforcement division. I would want to make sure the clarification that everyone understands when we talk about any manipulative or deceptive device or contrivance, that would also include any electronic algo-driven trading. Is that correct?
If the elements of the rule are satisfied, it matters not the vehicle by which the person perpetrated the fraud.
Thank you. I think that, again, issues a real challenge to both our surveillance division and enforcement divisions to recruit folks that have a strong understanding of how these devices operate. Thank you, Mr. Chairman.
Thanks, Commissioner Dunn. Commissioner Summers?
Thank you, Mr. Chairman. I just have a couple of questions with regard to the new authority and the fact that we're all familiar with the elements of proof for manipulation that we have worked with under 9A2. And if you could, first of all, answer what kind of difference there would be under the new authority between a false reporting case brought under 9A2 and under this new authority.
Sure. Under 9A2, as you well know, there's a four-part test. I won't recite all those elements except to say that artificial price is a key element in that test. Artificial price is not a required element under C1. So a false reporting case could be brought under C1, and assuming it's not within the false reporting that's already specifically defined underneath C1, there's a special provision for prohibition by false reporting. But let's just say it didn't fit in that bucket, and it was going to be brought under C1. The required elements, would be that you prove up a fraud, which would be the false report, that it was done with intent, and now intent could be satisfied by a showing of recklessness. So unlike a C3 claim or the old 9A2 claim, there's no requirement for specific intent under C1. Recklessness is enough. And then the last element would be that the fraud has to be in connection with a jurisdictional product, so it's a swap or a commodity in interstate commerce or a commodity for future delivery.
Do you think that there's any case that comes to mind for you that we would be able to bring under this new authority that we weren't able to bring under 9A2?
It's hard for me in the abstract to think of a fact pattern that the Commission could not have reached under one of its prior authorities. I will say, though, hearkening back to Commissioner O'Malley's opening comment, that there are several prohibitions. This is additive. This supplements the Commission's existing anti-fraud and anti-manipulation regimes. And it's additive in the sense that for the first time you have a manipulation rule that prohibits fraudulent conduct. And so in that way it's different and it's additive because now you can get at a market manipulation by fraud, and you can get there by proving it, the intent element, at least by recklessness. So it's new and it's additive in the sense that we can now have manipulation by fraud.
Thank you, Mark.
Commissioner, if I can just expound just a little bit on Mark's comments. Without going back to the cases that we filed or didn't make recommendations on, but looking at the types of conduct at interest and how I think Commissioner O'Malley hit it correctly about this continuum evaluate our cases. And so when we're looking at manipulative devices, say illegal activity, wash trading or prearranged trading, for example, and how that is going to work in our evaluation of determining potential liability under 6C1. So conduct, like for example, where someone says they are testing the market, and how in a facts and circumstances evaluation during our investigation, what does that actually mean to test the market, and what steps were actually taken in furtherance. So, under 6C1, we're looking at manipulative devices. We'll be looking at conduct that we see first as whether there's other violations of the Act, like wash trading or prearranged trading, or false statements that has been enhanced through this rulemaking, false statements to the Commission. Someone, for example, isn't upfront about the status of ownership of accounts, and that information might be useful in terms of getting a true picture of what actually the trading strategy is, as well as looking at what otherwise would have been legitimate devices, as we do in manipulation cases, but for intent become illegitimate vehicles to getting towards manipulative activity. So I think that the framework of the evaluation is in place, but we now have additional tools to assist us in doing that evaluation.
Thank you, Vince.
There's a little bit of version, document control. The document we all probably looked at last night said exactly what Vince said. It's basically to use or employ or attempt to use or employ any manipulative device, scheme, or artifice to defraud. I just want to confirm that's what we're talking about, not that I'm worried about what will go out of this building, but right now we had another document that might have got pulled off a SharePoint site internally that didn't have the final words in it.
You're correct, Mr. Chairman.
Okay, I just want to confirm that because I have the same, wrong SharePoint site thing here. Commissioner Chilton.
Mr. Higgins said exactly what I wanted to make a point on, but I'll put a little bit finer point on it. And it went to Commissioner Summers' question that this doesn't make the standard that exists currently, the manipulation standard that I spoke about and others have referred to. It doesn't change that. It is additive. So it's a new thing that we could go after folks for, along with the disruptive trading practice. So we've got more tools, but there's still that high standard that we've only had one successful manipulation case in 35 years on, correct?
That is correct. In the absence of fraud, and you have a pure C3 case, the standard doesn't change.
Okay. A lot of folks have asked me, why don't you get on with it and put this stuff in place? And one, we've been getting it on for a long time. The chairman set this whole process up on rules even before the bill passed, and you all and everybody else that's been in this building and in Chicago and New York been working very hard on these rules. So we are moving forward on them. But I also want to point out, and I guess I'll make it a question, we are prohibited by law from implementing this until next July. Is that correct?
That is correct. The statute in Section 754, which I mentioned in my presentation, prohibits the Commission from giving effect to any rule or provision before 360 days from enactment.
Okay, thank you. So even if it was all done today, we couldn't implement it and couldn't start working. Mr. Chairman, are we waiting to go around on the disruptive practices, or do I do that now? What would you prefer? I've got a question about disruptive practices.
What's discussion? It's meant to be separate, so...
Okay, I'll postpone that. Thanks.
Commissioner Amaya.
Mr. Chairman, I have a lengthy list of questions, and
that's why we're here.
And I would be happy to ask him. I'd happy to, if somebody wants to interrupt and take some turns going around, I'd be happy to break them up.
Do you want us to ask some of your questions for you?
Yeah, we might divide them up. I have several pages, and I can give everybody one. But I just want to be respectful of other commissioners, and if you have a question you want to jump in, please don't hesitate to cut me off. I'll just keep asking questions until I run out of paper.
All right.
I do appreciate the team's efforts here. We've worked very hard to make this a better product. I want to especially thank Laura Gardy, my senior counsel, who has done an outstanding job to improve this product as well, and I appreciate you all working with her. As I noted in my statement, I think we would all benefit, the market would benefit, we as commissioners and the enforcement division would benefit by understanding what practices are going to be allowed and not allowed. So that's a lot of the flavor of my questions. I'm going to try to enter.
And I was just going to say, because for some reason disruptive trading practices is separate, but we can do them all together, and I just then have to give Commissioner Chilton a chance to do his too on disruptive trading practices.
I'm happy to break them up as you see fit. Thank you. I just want to get a better understanding. 6C1, the violation, is it $140,000 per violation or $1 million? I'm trying to understand if this conduct is manipulation. 6C1. What would the penalty be?
Right. 6C1 is styled a prohibition on manipulation, and so if you violate the rule promulgated under that, the penalty set forth is up to $1 million in Section 753.
In order to satisfy a violation of 6C1, you must prove that there was, quote, a manipulative or deceptive device or contrivance. How will we prove that? And what makes something manipulative or deceptive?
Right. Those words, manipulative or deceptive device or contrivance, were first interpreted by the Supreme Court in the Ernst & Ernst v. Hochfelder case. In that case, the Supreme Court said those words were terms of art, and the meaning of which can be found only in the statute. In so doing, and this is under 10b law, they interpreted those words to mean fraud. So to violate C1 and the proposed rule promulgated thereunder, should it become a final rule, you would have to show that a fraud existed. Now, in the preamble, because I'm sure your next question would be, well, what is a fraud? In this context, fraud is a term of art. It's not associated with all the common law elements of fraud that you would have in, say, a state law action. Here, fraud in the preamble we propose to mean any conduct that impairs, obstructs, or defeats a well-functioning market or the integrity of the market.
Would an individual trading strategy be manipulated because each bid and offer will feed a price trend? How will we look at that? Are we going to look at by bid and offer, or will we look at a kind of a scheme?
Here's where it's difficult from where I sit, because these cases are really fact and circumstance specific. So and I'm going to leave you wanting, I think, with your question, because without those facts and circumstances, it's hard to give meaning to these words. They don't mean much in isolation. They mean something when they're enveloped by any given case. So I defer to others, but I don't have a good answer for you without a factual record around which to apply the rule.
But are there cases? I mean, because really what's happened is, and Senator Cantwell worked to ensure that FERC had these authorities and the FTC had these authorities, and now we have these authorities, as the SEC has over decades. So maybe is there guidance from other cases, Brad or Vince? Or
I mean, I do think that, as Mark says, this is going to be a case-by-case development, and when I was speaking earlier in response to Commissioner Summers, was focused on, for example, activity that we've already found to be illegal, because I think that making the argument in front of the court with respect to activity that already violates some aspect of the Commodity Exchange Act, and working an evaluation the statute is saying in furtherance of it's a manipulative device or deception, that will be should be persuasive to the court. As we talk about other areas of trading activity where arguably, it might otherwise appear to be legitimate trading, on the market, but we're offering that there is a manipulative scheme in play, and so the actual trading strategy that's being employed constitutes a manipulative or deceptive device under 6C1, and the courts will help guide us in terms of how those issues get decided as we go forward. So I don't think there's going to be a hard and fast rule coming out of the applicability of 6C1 after the effective date. There will be a lot of discussion in the cases just going forward.
But wouldn't we, I'm sorry, I'm just trying to help, but wouldn't the courts, I mean, maybe Brad, because you're the appellate litigator, wouldn't the courts look to a lot of the law that's been established by courts around the Securities and Exchange Commission enforcing the same words?
Yes, they would, and the proposed rule acknowledges that. It talks about the fact that there's been a lot of case law developed under Section 10b and Rule 10b-5, and that in many respects we are proposing that this provision be guided by the law that has developed around 10b and 10b-5 with appropriate modifications.
Thank you, Mr. Chairman. The manipulative or deceptive device must be, quote, used in connection with a jurisdictional transaction, correct?
That's correct.
Can you help me understand how the SEC has interpreted this and how we're interpreting this in our rulemaking, and maybe any flavor you can, is there a nexus between the conduct and the jurisdictional transaction?
Right. So the Supreme Court again here has weighed in on this specific issue in connection with in the SEC versus Anford case, which came down in 2002. And in that case, the Supreme Court breathed life into this three-word phrase, in connection with, by saying that so long as the fraud coincides with an SEC jurisdictional transaction, there is that sufficient nexus, as you said. Now, the court was careful in that case to not be unlimited. I believe it's footnote 4 of that case. The court went on to say, which was a 9-0 case, by the way. I think it's kind of important to make that point. It was unanimous. The court said, when we're saying within connection with, it's not limitless. So they gave the example of a stockbroker who steals cash, not a money market fund, but cash from a client's account and uses that cash to buy real estate. There is not a sufficient nexus, and you would not violate 10b-5 under that fact pattern. So it's broad, as is the entire rule. It's meant to be flexible, but it's not limitless.
I think I'm down to my disruptive trading practices question, so we can...
The manipulation questions, right? I mean, I gather, and I think Commissioner Malia's questions are very helpful, is that we're not alone at this because there's a tremendous amount of case law. I thank you for reminding me. It's a tremendous amount of case law, and that's what I understood, at least I understood that was the intent of Congress here, is that we would have a new fraud-based manipulation. It wouldn't be, as you say, unbounded, because it would be grounded in this case law. And you've answered a very important second question, Mark, is that we're not trying to incorporate the insider trading piece of that case law. But could you answer those two pieces of the question?
Yeah. Justice Rehnquist said that if of 10b-5, that from an acorn a judicial oak has grown. And that's, to your point, there is...
Justice, was that?
Rehnquist. And so he's making the point in that statement that there is a huge body of case law under 10b-5 that we can avail ourselves of, and I'm sure courts will too as they interpret it. So yes, we will be guided by, but tailored to our specific mission. As far as insider trading, just reiterate that this rule does not prohibit insider trading, nor does it impose any new duty of disclosure on any market participants. There's a specific provision in 753 that says you do not have to divulge inside or confidential information to the public before you trade. However, if you do speak, you must speak fully and completely and not be misleading in your statements.
Other questions, Commissioner Malia?
Mr. Chairman, your question did bring up, I'm trying to, and what I think will be helpful is helping everybody understand how this continuum works. As I noted, 982 is in our statute, obviously, and we're not getting rid of that. You want to elaborate on what that relationship is?
Yeah, I think it's status quo as far as 982. So I think today, just as we have in the past, a person, depending on the right facts and circumstances, could conceivably be charged with both the C1 violation and a 982 violation. The Congress was explicit that 753 does not upset 982 or the applicability of 982.
Now, you've showered praise on, obviously, the SEC and FERC for their new authorities. We are not without our own fraud authorities. And how will those be, and case law therein. So how are we going to use our case law? Are we going to abandon it and just go for the SEC, or are we going to stand by it?
No, we do not, and we're clear in the preamble, and as I tried to make clear in our precedent, this new authority, it's new, but you're right. We have decades of precedent policing fraud, manipulation, and we have no intention of abandoning that. I think any manipulation case that was brought before could still potentially be used as guidance in cases going forward.
So now we have the SEC, the FERC, our fraud, 909A2. Obviously, this is extraordinarily complicated. We've given you significant tools. Congress has given us significant tools, obviously, with fraud and manipulation, and change the price element a little bit here. Now, how do we inform the industry of how they're going to be charged, what the rules are going to be going forward, what applies? Are they going to be a 6C1, a 6C3, 9A2, fraud versus manipulation? I mean, you did dodge the 140 versus $1 million question earlier on whether it's going to be fraud or manipulation because it has that reckless standard in there. What's the market to think about all this? How can we give them the confidence that, or what bin they're going to be bucketed in? I guess there's no confidence in this, but.
Well, again, I'm not trying to dodge your questions. I'm simply saying that this area of the law is extremely fact and circumstance dependent. So to tell you today how somebody would be charged tomorrow is foolish from where I sit. So in that respect, or with that caveat, everything is still on the table. And it always will be. If a specific fact pattern merits a 4B charge but not a C1 charge, that would be something that the division would consider. And a fact pattern that may fit that profile is where you have somebody that is perpetrating a fraud, they have the requisite intent, but there isn't the sufficient connection to a commission jurisdictional transaction. They're selling widgets or something like that aren't jurisdictional. So then maybe you have a 4B fraud and not a C1 fraud. But as you can see, with every new fact, there's a new permutation and a new analysis that goes into this. So,
thank you.
Could I add just one comment?
Please.
The one thing that I would hope would give comfort to industry is the fact that most of the provisions that you just recited, Commissioner Amalia, require specific intent or intent to defraud. So, in most instances, with the exception of recklessness under C1, if you are acting without fraudulent intent or without specific intent to manipulate, to affect the price, you should be okay. It's when you are acting with that intent that you could get into trouble.
And just one other point with recklessness, I want to be real clear on this. It's not your standard tort definition of recklessness. The courts are very clear in the securities context, and we are in our rulemaking in our preamble by the cases we cite. When we say recklessness, we mean a lesser showing of intent. We don't mean a higher degree of negligence. I hope that's illuminating, but I just want to make the point that, people aren't, I don't think, going to stumble into a C1 violation. You had to have the requisite bad intent.
Thank you both.
I can tell we have 4 extremely accomplished and knowledgeable lawyers. I didn't go to law school, but I followed most of that, so thank you.
Mr. Chairman.
Yes, Commissioner Chilton.
I just wanted to compliment you. I appreciate Commissioner O'Malley's questions. I think they're good questions. As I think all of us here know, and particularly the chairman, this language was a compromise that was sort of banged out at the 11th hour of the conference. And while people may write it differently, if it were one person or another, Congress wrote it, and it is the law. And so this is what we're left with, and I think you all have done just a really spectacular job of putting a lot of meat on the bone. I do look forward to the comments that we'll get on this, because I do think there's some legitimate questions. But I compliment you on the work you've done so far.
If there are no further questions, I'll entertain or call the question. All those in favor say aye.
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 Aye. Any nays? It being unanimous, 5-0, we'll send this one as well to the Federal Register. Some of you can stay, all of you can stay. Disruptive trading practice. Brad, don't go anywhere.
Share it with us, Brad.
What's that? We have 4 great lawyers here. I just want to don't give you up. So, Bob, are you going to present this one?
Yes, I am. Thank you, Mr. Chairman, and good morning, Mr. Chairman and Commissioners. I would like to introduce our team members for both anti-manipulation and disruptive trading practices matters we are discussing today. As you can see from Mark's presentation, a lot of hard work and very high-quality work was put into these efforts. Ralph Avery, Mary Connolly, and Maria Goodell from the Office of General Counsel, William Penner from DCIO, Kirsten Sorensen and Michael Pennick from OCE, James Goodwin and Dave Cass from DMO, and Mark Higgins, of course, Brian Walsh and Jeremy Cusimano from Enforcement. I'd also like to thank John Mark Buppa, Brad Berry, and Andre Karolinko for their invaluable assistance in these matters. Today we're here to discuss an advance notice of proposed rulemaking in ANOPR concerning Section 747 of Dodd-Frank, which prohibits, among other things, specific trading practices that are disruptive of fair and equitable trading. Separately, and not part of our proposed rulemaking, Section 747 also makes it unlawful for any person to enter into a swap knowing or acting in reckless disregard of the fact that its counterparty will use the swap as part of a device, scheme, or artifice to defraud any third party. Section 747 of Dodd-Frank In Section 747 of Dodd-Frank, Congress expressly prohibited certain trading practices that it determined were disruptive of fair and equitable trading. Congress made it unlawful to violate bids or offers, demonstrate intentional or reckless disregard for the orderly execution of transactions during the closing period, or is of the character of or is commonly known in the trade as spoofing, and spoofing is defined as bidding or offering with the intent to cancel the bid or offer before execution. Dodd-Frank Section 747 grants the Commission optional rulemaking authority to promulgate such rules and regulations as, in the judgment of the Commission, are reasonably necessary to prohibit the trading practices enumerated above and any other trading practice that is disruptive of fair and equitable trading. The prohibition on 3 disruptive trading practices specified in new Section 4CA will become effective 360 days after the enactment of Dodd-Frank Act. In this proposed advance notice of proposed rulemaking, staff requests comment to 18 questions, ranging from whether the Commission shall promulgate additional guidance on the 3 enumerated statutory provisions, promulgation of prohibitions against additional disruptive trading practices, supervision and monitoring requirements, and application of the rules to electronic trading and algorithmic automated trading systems. For example, some of the questions contained in the ANOPR are, should the Commission provide additional guidance as to the nature of the conduct that is prohibited by the specifically enumerated practices in the statute? How should the Commission distinguish spoofing, as articulated in the statute, from legitimate trading activity where an individual enters an order larger than necessary with the intent to cancel part of the order to ensure that his or her order is filled? Does a partial fill of an order or series of orders necessarily exempt that activity from being defined as spoofing? Should there be obligations to supervise against the prohibited trading practices? Similarly, should executing brokers have an affirmative obligation under the rules to ensure that customer trades are not disruptive? Should the Commission consider promulgating rules to regulate the use of algorithmic or automatic trading systems to prevent disruptive trading practices? And if so, what kind of rules should the Commission consider? Should the Commission consider promulgating rules to regulate the design of algorithmic or automatic trading systems to prevent disruptive trading practices? Should the Commission consider promulgating rules to regulate the supervision and monitoring of algorithmic or automatic trading systems to prevent disruptive trading practices? And should the Commission promulgate additional rules specifically applicable to the use of algorithmic trading programs, trading methodologies and programs that are reasonably necessary to prevent such systems from disrupting fair and equitable markets? Staff is recommending a 60-day comment period for this advance notice. Staff also intends to hold a public roundtable discussion on December 2nd, 2010, to provide a forum to discuss the questions contained in the NOPR, as well as other issues prospective commenters may raise. Thank you, and I'll be happy to answer any questions.
I think I'm supposed to first entertain a motion, so entertain a motion.
So moved.
Second. With that, just questions on the this. I don't really have. I just want to say I'm supporting the proposed advance notice of proposed rulemaking. I think that Congress, in granting us these additional authorities on disruptive trading practices, they listed 3. You put in the questions A, B, and C. But I think it is helpful to ask the public how to best give meaning to those 3 points, give some specificity to those 3 points. Not everybody in the marketplace knows what it is to, quote, violate a bid or offer, but it's in statute now. And not everybody knows what spoofing is. So I think I'm glad that we would ask questions. I was more hopeful that in the midst of the last 3 months we'd get more public comments. But how many comments have we gotten into our email boxes on this?
On the disruptive trading, we did not receive any.
So I am really hopeful that market participants understand that at least this chairman's intent to move forward with rulemaking on this. I think it is incumbent to do rulemaking to give greater meaning to the first 3 points, the violating bids and offers and spoofing and so forth, but also to consider whether we add a D or an E or an F as the provisions provide. In the 18 questions, we ask a series of questions also with regard to automated trading. And we're going to have a staff roundtable, I think is going to be December 2nd. We've had a lot of other staff roundtables, so this will probably take a similar format, but with our busy schedule through November, this was just frankly the first time we can get this thing scheduled. But I think that's going to be very helpful. And moving forward, these public comments will also be informed by the Joint Advisory Committee, the CFTC and SEC Joint Advisory Committee, whose I think we've scheduled November 5th is our next meeting of that. But during this period of time, I wouldn't be surprised if we have some comments and advice back from that committee or an additional meeting. So I think all of this, the public comment period on these 18 questions, the Joint Advisory Committee, I hope market participants, though they're also busy, they're busy making markets and hedging their risks and so forth. They're busy trying to react to our rules and the SEC's rules, but I hope that they would help us out on this one. But I don't have any specific questions. Commissioner Dunn?
Thank you, Mr. Chairman. I have no specific questions on this. I do look forward to that roundtable on it. I appreciate the hard work in there, and I would implore the public to take part. I'd also like to thank all of the staff and the participants in the roundtables that we have been having. I think last Friday's was a very, very good roundtable event, and I really appreciate the hard work that goes into that and what's coming out of it.
Commissioner Summers?
Thank you, Mr. Chairman. I'd just like to say that I agree entirely with what you were just saying about these rules and being able to get the public comment, because this rulemaking, although this rulemaking is optional, I do think that the practices that are expressly prohibited under Section 747, the A, B, and C, are less than clear. And I would suggest that any sort of rulemaking that we would do, or our goal through any sort of rulemaking here, would be to make them as clear as possible. I know this is enormously complex, and that working through these sort of complicated issues is not easy, and I want to say how much I appreciate this team's effort in this area, but that the public needs to understand that this roundtable on December 2nd is really important for us. I think, let's see, if we put the rule out today, they'll have about 3 weeks after that roundtable to then get their comments in under a 60-day comment period. So just to suggest to the public that if they have certain suggestions with regard to the ability for us to make these rules very clear, that they participate in this process.
I thank you. Actually, they'll probably get an extra week. It always takes about a week between us and the Federal Register. That, by the way, for the press is not us. We usually hit the send button shortly or within 24 hours. But the Federal Register has a process to get it in the Federal Register that's been taking 6 or 7 days. Commissioner Chilton.
Thanks, Mr. Chairman. That last point that Commissioner Summers was making about, making these things as clear as possible, I think is important. But what we've learned is that, we also want to preserve some discretion in the future, because you even look at what people are thinking now about robotic trading, about algorithmic trading. Had the flash crash report, for example, come out, 9 months ago instead of after the bill was passed, maybe there would have been a provision in the law that would sort of outlaw algo anomalies. So I think we just need to be cognizant that this authority can be changed in the future if we see something else. Folks are always looking at ways around the laws, rules, and regulations, and this, while I agree with Commissioner Summers, to be clear, it also allows us the possibility to change things in the future. There was an old Styx song, Mr. Roboto. You remember what it said there? The problem is plain to see, too much technology. Now, I don't think there's too much technology, but we've definitely seen instances this year where algos go wild, and it costs people money. And it's not acceptable for the trader to just say, sorry, my bad. To me, it seems like that should be punished in some way. The chairman and Commissioner Summers were talking about not getting a lot of comments on this. I gave a talk yesterday in Las Vegas to 200 energy traders, and they weren't asking many questions, so I asked them some questions. And by the way, the first question is 70% of a market too much? And people raised both hands. The other question where I got unanimity was, should algo traders whose algo programs sort of go wild and impact royal markets, should they be held accountable? Everybody rose their hand. Now, that's not an official public comment, but it seems to me that even though you asked these 4 questions in here, 15 through 18, about algo traders, that we may want to add one more. I don't know if my colleagues would agree, but something about, should algo traders who royal markets be held accountable, and if so, in what fashion, or something like that. And if the staff would like to fine-tune my question, or if the chairman would like to fine-tune it.
I'd be glad to second it if you change royal to disrupt, because I think that's what this is, a disruptive trading practices or something.
Yes.
So that's an amendment we'll vote on at the proper time.
Yeah, I'd like to associate myself with Commissioner Chilton's remarks on this one. It's a good question to ask.
I'll move my question.
All right, so all in favor of the amendment to add the question?
Aye.
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 Opposed? I think it's unanimous.
Thanks, Mr. Chair.
Commissioner Malia has the rest of the list of 2 pages.
That's right.
We're ready.
And I'd like to associate myself with Commissioner Summers' comments on this issue. These are complicated. The specifics matter, and we're asking some questions. But again, I'm going to try to inquire with the staff on how some of these will be treated going forward. Obviously, under 4CA of our current authority, the first 3, the A through C, might be covered. How do you respond to that? I mean, is this redundant with 4CA or not?
Are you asking whether? Could you repeat the question? I'm sorry, I didn't quite follow.
The new disruptive trading practices, and
right.
Are they covered under 4CA already?
Yes.
Okay. The disruptive trading practices described in Section 747 as described in the ANOPR generally prescribe pre-trade conduct. Absent an ad hoc analysis, how will the Commission monitor for these violations?
Monitor in advance?
Monitor it all. Pre, post.
We've been working with the DMO, and we will continue to work with them to come up with different markers that they would be able to use to try to figure out whether there would be violations of bids of offers. But I think it's a little bit premature to say what they would use for their surveillance activities. That's the purpose of this ANOPR, is to get more comments and, as Commissioner Summers saying, put more clarity around these terms. And as we get more clarity, then I think we can build some surveillance programs to be able to look at those type of practices in advance.
What are the civil monetary penalty attached with each of these violations?
If they would be brought under Section 47 alone, they would be $140,000 plus restitution as well. The $1 million a day penalty applies only to manipulation.
Could these be viewed as a scheme and therefore subject to the manipulation, $1 million a day?
There could be circumstances, depending on the facts and circumstances, that conduct which may also violate 747 would be a manipulation.
With regard to the bids, violate bids are offered, what are the elements of a violation of this provision? What is the level of intent specifically are we looking for?
That's exactly. I'm sorry. That's what we're seeking comment on. Right now, the statute doesn't state what the intent would be for violating bids and offers. I think you would be looking at both specific intent and recklessness behavior.
Are there any instances that you can think of where a trader may bid through an offer but not be in violation of this provision?
I'd rather not speculate on various fact patterns there. It, again, is very fact and circumstance specific.
How about a hypothetical? What if a price is on NYMEX and Globex? They pick a price that might have been lower on one rather than the other, and would that be considered bidding through the offer? And obviously, with all these SEFs coming into play, how will we deal with that?
We'd have to look at the totality of the circumstances, and we'd have to be looking at the intent.
Commissioner Amalia, could I just
sure.
interject? Excuse me. Before you got too far down your list and didn't, I wanted to call this to your attention. I'm looking at Section 4CA of my Green Book, and it's not clear to me how that intersects with the disruptive practices in 747. I think one of the questions you asked was whether the disruptive practices that Congress spelled out in 747 are already covered by Section 4CA, and I don't see that they are in the terms that Congress used. It may be that for the provision that you're referring to is a broad provision that could encompass some of those, but I don't see, for example, in 4CA, I don't see anything about violating bids or offers or spoofing. So I wanted to, I'm not sure that when Bob answered that question, he was meaning to say that, I think you said 4CA.
Right. As I understood your question, Commissioner, it was the statutory authority, A, B, and C. No rulemaking is needed to give effect to those. And then we are promulgating a rule that reflects those, that mirrors those already enumerated provisions and giving more meaning to them. That was your question? Okay, thanks.
With regard to the reckless intent on the orderly execution, disregard for orderly execution of the close, do we have any thoughts on how you might define orderly execution?
That's a particular area that we're seeking comment on. We're also seeking comment on what actually defines the closing period, good activity in advance, which are then executed during the period, what all would be encompassed to cover those terms. They're not defined at all, and there's little, if any, legislative history on the subject.
A little concerned about the vagueness of this prohibition that might prevent people from trading in the close. You know, we have these trade at settlement TAS contracts, and on the exchanges, how will those be treated?
That's going to be the opportunity in our next round to be able to clarify those issues, address them specifically. I mean, what we're looking at here, although it doesn't use those type words of marking the close, banging the close, that's the type of activity that we're trying to prohibit here, not legitimate behavior during the closing period.
And, certainly with respect to using TAS, the TAS trading activity is subject to a pending commission complaint against an entity by the name of Optiver. But in promulgating the rules at the exchange and the conversation with the exchange about conduct that's otherwise disruptive on the market and what the exchange is doing to ensure that there is sufficient liquidity during the closing range to accomplish the goal of the close to get an appropriate or a meaningful settlement price, and how is that activity that there isn't attraction by, say, distraction during the closing range where we're affecting what the price should be.
In question 12, it's a disorderly execution question. How are we defining that? Are we asking for a definition? Do you have a sense of what the definition might be? You have an opinion on it?
No.
Okay.
I mean, other than again, this would be this is a facts and circumstances, I think, analysis that we're going to have, getting some input certainly from the industry about where they would see maybe as markers currently of activity that's disorderly, but the expectation is that we're going to be developing this in the cases as we evaluate the trading strategies and make the recommendations to the Commission and have discussions with these traders about whether we see the conduct as being violative.
Let me just help Commissioner O'Malley. Maybe this is an amendment, but on question 12, can you add and as an amendment, see if I have support, and if so, because you have an if so, what size? Well, you do have. Well, you don't need it. You say, how should it distinguish between orderly and disorderly?
Right. And to the size question, my next question is, how are we going to define particularly large orders?
Well, that's just one of the things we're seeking comment on. We have some. What we're trying to do is get objective criteria that we can use for what would consider a large trade, so that it wouldn't vary over the circumstances. And there are regulations that say what. 1503 in our regulations right now, which have some guidance, but that may not be appropriate in this circumstance. So we're looking to see and get comments on what would constitute a large trade, and then once we have a large trade, when it's, as the questions are asking for, concerning disorderly execution of those, does that vary over time? Does it vary under the circumstances, the market conditions? We're looking for comments along those directions, because it can be a large trade can go in at a certain time in the market and not cause a disruption. Other times, depending on the facts and circumstances, should there be a monitoring requirement? That's what we're asking. Another question, where you're monitoring this large trade as it's coming into the market and taking into account considerations such as what's changed during the day, what's changed when they made the decision to execute that transaction. All different factors that we want to look at. We're asking the question, should there be additional controls when you're having a large trade which would have the potential to disrupt the market?
Well, you have a very difficult job in defining this with regard to the Technology Advisory Committee. We've asked many of these questions, and we either get different definitions or different ideas about what the definitions mean for various trading strategies. So good luck.
And we look forward to working with your committee to try to help solve this problem.
Thank you, Commissioner O'Malley, for your thoughtfulness on this. If there are no further questions on disruptive trading practices, advance notice of proposed rulemaking, I will then call the question. All in favor say aye.
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 Any opposed? The ayes being unanimous, we will be sending it on to the Federal Register. I've to find the right thing to read from here. If I'm allowed to do this, I'm just going to, this is some housekeeping or trying to set up the new meeting schedule and so forth. But first, I need a unanimous consent on something. The Sunshine Act and Commission rules require at least 1 week notice of the subject matter to be considered at a public meeting. And I actually asked the lawyers yesterday, could we consider today what our next meeting is? Apparently, we didn't notice the public that we would just be talking about when our next meeting was. So I would like a vote to approve that, that though we didn't notice that we would vote on what our next meetings are, that we just vote to pick our next meeting. So consequently, I guess in order to ensure that we conduct this meeting in accordance with the Sunshine Act, Chair will entertain a motion that the business of the Commission requires a change in today's agenda so that we can actually discuss when our next meeting is.
So moved.
Second.
All in favor that we...
Aye.
Any opposed?
Aye.
So we did that administrative thing. Now, in terms of our next meetings, we always want to be in accordance with the Sunshine Act. In terms of the next meetings, I think that Deborah Ridgely, who does all this scheduling between us, has three. I said 3 dates in November. One of them might end up being in December 1st, but December 10th. We'll put this all in the Federal Register, but December 10th. November 10th. I'm sorry. November 10th from 1 to 4 in the afternoon. November 19th, which must be an all-day thing, but it says 9:30 to 5:30. I think we have calendared internally, 6 or 7 of these things that would probably be then. And then December 1st, actually, even though we were trying to do November 30th, I think somebody wasn't available. So December 1st, again in the morning, 9:30 to 12:30. But so I'd like to offer a motion that those are our next 3 meetings, and we'd, of course, as we have been, it's 7 days before putting on our website the actual agenda items of the meeting. Do I hear a second?
Second.
All in favor, say aye.
Aye.
All
Aye.
Any opposed? No opposed, then that's carried unanimous, and our next 3 meetings are the 10th, the 19th, and December 1st. I do think that we still, just for the press, we're sort of anticipating 2 meetings after the December 1st one in December. We're human. Some of this is going to slip inevitably. I mean, we're getting down to crunch time, so there'll be some of these. There'll be, just inevitably, because we're coordinating a lot with the SEC, the Federal Reserve, and others as well. Do I need to also do a unanimous consent for any technical corrections?
Yes.
So I have one last thing to do from the script. So at this point, I also ask unanimous consent to allow staff to make technical corrections to the documents voted on prior to sending to the Federal Register. And I'll make that motion. For that. All in favor? Aye.
Aye.
Again, I want to thank everybody. I don't know if my fellow commissioners have closing remarks, but we've identified 30 topic areas, and we're plowing through. Whether we're through a quarter or a third, we know that this is an awful lot to get done, but we're trying to get these out so the public can comment. They'll change. The final rules will be different than the proposals, all in accordance with the Administrative Procedures Act. But I look forward to seeing you all back here on November 10th. Any other closing? No. With that, the meeting, I guess I need a motion to adjourn the meeting.
So moved.
Second.
All in favor? Aye. Meeting's adjourned. Thank you.
Aye.